Good morning, everyone. I'm Judge Sylvia Holmes. If you could, please wave at the screen or give me a thumbs up. Otherwise, indicate that you can hear me clearly through my audio. Okay, I got lots of responses. Fantastic. Thank you for being with us. We have 7 matters on our docket today. I've got some defaults, some motions, and some actual trial by court. So we're going to reach everyone in kind of standard order here. You are welcome to turn your screen off unless if your case is not being heard. And that way you can sort of preserve your bandwidth. Also, we don't want everyone to get to see your expressions to the rest of the cases. That's totally fine. But please stay nearby your device, because when we reach your case and we're calling your name, if you're not coming back, that's the same as if you have left the courtroom, okay? If you do need to step away for some reason, let's say you need to use the restroom or something else, send a message to our court clerk in the chat box that says, I'm running to the bathroom, I'll be back in 5 minutes. That way, if we do reach you and we're not hearing, then we understand where you've gone, okay? All right, fantastic. First case that I have this morning is going to be a default matter. This is J3CV 25002798, Greg D'Antonio versus Opus Immersive. Do I have someone here on behalf of D'Antonio?
Yes, present, Greg D'Antonio.
Good morning, sir. Thank you for being here. Do I have anyone on behalf of Opus Immersive? Anyone at all on behalf of Opus Immersive Incorporated? The cost 252798. Well, Mr. D'Antonio, we've not had any response from the defendant. We did receive back the return of service as being complete. We received that return of service. Alyssa Gaitan, a corporal here with constable's office, sought alternative service, which we granted. She made 2, 3, 4, 5 attempts in person, and she did mail it and then submit a copy as well with email. We have to approve that social service. So we do have reason to believe the defendant has been made aware and was served, but has not appeared before the court. All right, Mr. D'Antonio, you raise your right hand. I'm going to swear you in.
Sure.
Will you please state your full name for me?
Greg D'Antonio.
You understand that by appearing in court and offering testimony, you are swearing to tell me the truth, the whole truth, and nothing but the truth under a penalty of perjury. Do you so swear?
Yes.
Fantastic.
I do.
All right. Mr. D'Antonio, how much are you seeking from the defendant?
I believe I was submitted $3,000.
Okay, let's take a look. You purchased something but never received it. Is that right?
That is correct.
Okay. And what is Opus Immersive? You said an Opus sound bed. I'm curious. What's that?
It was supposedly a bed that generated healing sounds.
Oh, okay. They have those for kids. I had a lawsuit over one called Snoo. It's like a thing that rocks the baby to sleep and it plays noise.
Oh, that's cool. I never heard of that.
I didn't either until that lawsuit, but apparently it's the hot thing for new parents if you can afford it. So this is the adult version. All right, Mr. D'Antonio, in your original petition, you were seeking $4,600. Is that the actual money that you spent to purchase the bed?
No, it was less than that. It was just that full amount was time and effort and money spent, trying to recollect my funds.
All right, so the court can award you your actual out-of-pocket expenses and your cost of court. I can't give anything for your time, although I absolutely morally understand why you'd like it. Legally, what I can do is give you your actual damages. So what did you actually spend for the bed?
I sent it this morning. I believe it was about $1,800 total.
Okay. Let's take a look. Like you said, you sent in something this morning that may have come through. Documents might have come in real quick. You sent it this morning, you said?
Yes, ma'am.
Did you send it to the JP3 or the civil email? Do you know?
I believe it was a JP3 email.
Okay.
Give me 1 second, Judge. I think I was able to locate it here.
Okay. We have a bunch of firewalls, so it has to go through like 3 layers of protection before it can come through, especially if there's anything attached to it. Always fun.
Yeah, no problem.
Go ahead and take a look. I do find that our plaintiff appeared and requested. Defendant, though duly served, has failed to appear. Judgment will be granted for the plaintiff. In addition to your actual cost of court, you would receive your actual damages, and we're going to bring that in here and prove that up. Other than the money that you spent for purchasing of the bed and then your cost of file in court, have you had any additional out-of-pocket expenses?
No, ma'am.
Okay. All right, I'll give you some information.
It'll be in the documents.
I'm sorry, Brashay?
I put it in the documents.
Oh, great. Let me just refresh. Perfect. There it is. Plaintiff's exhibit. Looks good.
Oh, that's not it.
That's the mailing
That's what it
address. We need that one too. We need that one too. I'm not worried about the defendant being in the military. I don't think Opus Immersive and Incorporation could enlist, but we always check on that.
Let
But
me
I need
just
the last
screenshot.
address. That's an important part. All right. Mr. D'Antonio, I'll give you a bit of information while we bring in the information for the number. So after the judgment today, you have 21 days to seek an appeal, as does the defendant. We will automatically send a copy of the order, both via email and regular mail to the defendant. Either party can appeal, and in small claims in Texas, you don't have to have a reason to appeal. You actually could appeal and say, she should have given me more money, right? That might sound strange. But if either party appeals within 21 days, then the case just goes to another court, and essentially you'd get notice from that court, and you would go and pretty much have the same kind of a hearing, okay? If no one
Okay.
does any, judgment becomes final on day 22. And if you're interested in trying to collect your money or do anything further, the phrase that you might look for is post-judgment collection.
Okay.
All right, and there's lots of information on some of the websites on free legal resources. You know, if you have won a judgment, what do you do to try to collect it? But that's the phrase, post-judgment collection. All right.
Okay. Thank you.
All right, let's see if that document's come in now.
Hold on, Judge. It's trying to save it, but it's giving an error. Hold on 1 second here. Okay, try now to refresh your documents.
There it is, invoice. Technology's fun, y'all. It never fails. We're always doing something. All right, thank you for ordering your Opus sound bed. All right. I gave you a discount. Well, that's nice. All right, you paid $1546.07. Okay. Judgment for plaintiff, $1,546.07 plus your cost of court, and then it will accrue interest going forward at 6.75%. All right.
Thank you.
Have a good morning, sir. You're all excused. Thank
You
you for
too.
coming.
Appreciate it.
Right, our next matter is also marked as a default. This is cause 25-1598, Avery Meredith versus Kansas Michalke. Do I have someone here on behalf of Meredith?
Present.
Good morning. Thank you for being here. And do I have someone on behalf of the defendant, Kansas Michalke?
Yes, I'm here.
Good afternoon, or good morning rather, to you both. All right, now, Ms. Michalke, you did file an appearance and we have received that answer. And so because the defendant has at any point up until the day of the hearing the right to appear, you have done so. So what I would say to both parties is we were set for this to be a default. Ms. Meredith, you were prepared for this in a different way. We do not want to disadvantage either side. So typically what the court would do, since Ms. Michael has made sort of a late appearance, we would reset the case typically by about 60 days. And that gives both parties time. If you wish to reach out to one another, you can, you don't have to. If either of you need any additional information, you can seek that from the court. And if we think it's appropriate, we can grant it. Otherwise, we would see everyone back via Zoom the same way in about 60 days. Ms. Meredith, do you have any questions or information you want to share or any objections to a continuance? You're on mute. You'll have to unmute. Press *6. There you go.
I don't have any objections.
Okay. Ms. Michalke, any questions about a reset of 60 days?
No, would I be able to submit more evidence
Absolutely.
as I've already submitted that as well? Okay.
So you both have plenty of opportunity. If you need to submit any documents that you want to use for, evidence purposes, you can send that to the court in advance. Again, there's nothing that prohibits you from reaching out to each other. You do not have to do that, but some people are afraid like that you cannot do that, and there's nothing here that prohibits it. All right. Any other questions? All right. Well, then thank you both for coming this morning, ladies. We will reset you both. We'll give you a notice in about 60 days. We'll give you notice that the hearing will be about 60 days out. It won't take you that long to get it. Okay. All parties are excused. Thank you.
Thank you.
Get back and finish. Mr. D'Antonio. All right, Rashay, I've signed the order from our first one. That's all completed.
Thank you.
Right. All right, now, have we had all parties appear on behalf of 25-2449? Do I have someone here on behalf of Andrew Tagnella?
Judge, this is actually Andrew Talagani, counsel for defendants. I was in the waiting room from the Zoom information I was given, and at 9:17 I got a little worried, so I called in, and they said they sent out the wrong Zoom info.
Mhm.
So they just emailed both myself and Mr. Tugnell as a pro se plaintiff. So I just jumped in the room. Hopefully he'll be joining us soon.
No, we
I'm-
absolutely understand that, Mr. Tallahassee. That's why I'm asking. So
I'm
if
on.
the court has made a mistake and sent the wrong Zoom link, it may be that we have to reset the hearing.
He
I'm
is
on.
here, Your Honor.
All right, all right. Do I have someone on behalf of our plaintiff, Andrew Tugnella?
I'm here, Your Honor.
Fantastic. Mr. Tugnella, you're in quite a bit of darkness. I can't really see you. Is that the way you want to appear?
Nah, dude, what the fuck, man?
Okay, remember that we can hear you, sir. That's much better. That's much
I
better.
didn't say that.
Okay, whoever
Yeah,
said
that
that,
was-
remember that you're
I
loud
don't
enough
know who-
to, and in
Yeah, I
court.
don't know.
Okay. All
That
right.
was not me.
Okay, I appreciate that. Well, you look much better. I can see you now. All right. Good morning to you, sir. And good morning, Mr. Tallahassee. You're here on behalf of the defendant, Westgate Family Dental and High Point Dentistry.
Correct, Judge.
All right. Now, today we are here for a motions hearing, and this is defendant's motion to dismiss, correct?
Yes, Judge.
All right. Tell me why the case should be dismissed.
Well, Judge, there are two independent grounds for dismissal. First, plaintiff's claims are barred by the applicable 2-year statute of limitations under Chapter 74. Second, and maybe an easier way to dismiss it, is failure to serve an expert report after the 120-day deadline that's required under 74-351. The SOL, the statute of limitations issue was, he's alleging that there's an issue with the Crown. It was placed July 29, 2021. The 2-year statute of limitation expires July 29, 2023. This lawsuit wasn't filed until 2 years after that. Regarding the expert report issue, the defendant's answer was filed September 9th, 2025. There was no report ever filed. The deadline expired in January, and Chapter 74 applies automatically by operational law. It doesn't require defendant to invoke it. It doesn't require defendant to notify the plaintiff that the statute applies. And Judge, in your, I think it was your April 9th, 2026 ruling, you confirmed that this is regarding a dental crown, dental treatment, and Chapter 74 applies. So 74-351B, it's written in mandatory language. It provides that when an expert report is not served, the court shall dismiss the claim with prejudice and award the affected healthcare provider reasonable attorney's fees and court costs. The legislator, for better or for worse, removed discretion from the court once those conditions are met. Here, this is a Chapter 74 case. No expert report was served. Therefore, dismissal is mandatory. Just to quickly counter plaintiff's last filing that I didn't reply to in writing because I didn't feel the need to, but he talks about his good faith efforts to resolve different treatments with the same regarding different dates and different teeth. That doesn't excuse the expert report requirement. It has nothing to do with this case, quite frankly. And his pro se status, although I feel for him, it doesn't create an exception to Chapter 74. Pro se litigants are held to the same standard as attorneys are. I've had to file the same motion all over Texas in JP courts, and actually sometimes in district court with attorneys who don't know to file this expert report. And so I guess I'll conclude that defendants would like the court to grant the motion for summary disposition, enter a motion to dismiss the claims with prejudice, award attorney's fees. However, I don't want to put Mr. Tugnell in a worse place than he started. I'm willing to waive the request for attorney's fees so that we can have this matter dismissed and everyone go their separate ways, Judge.
All right. Thank you, Mr. Tallahassee. Good morning, Mr. Tugnella.
Good morning, Your Honor.
All right. Let's take them. There's two different issues that have been raised by the defense counsel. And the first one is related to a timing issue. So he says that the crown you received was that you had that work done in July of 2021. Is that correct?
Yes, Your Honor.
All right. And he says that as a result, the statute of limitations for any claims that could have come from that crown would have run in July of 2023, but this case was filed in 2025.
Yes, Your Honor. Your Honor, the limitations clock was told under the Texas discovery rule. The crown is glued inside my mouth. I have no visual or technical way to inspect a crown. The crown was completely asymptomatic until late 2024, when my new dentist discovered it had become unsealed. Furthermore, because of the other issues that I may or may not talk about in 2023 and 2024, And because I'm a normal citizen with $2,500 of insurance benefits per year, I had to wait until January 2025 to get that work done. I worked and issued emails, much like I did on the last issues for the other failed crown and for the botched root canal. I followed the procedure, much like receiving this check, which I'm holding up for $12,452.66 from Westgate Family Dental. And I tried to resolve this, Your Honor, in out of small claims court. And so because
Mr.
the,
Tagnella,
yes,
when did you first send a written request for payment regarding the crown?
in July
Of what year?
of 2025.
Okay, so that is definitely 2 years out the statute of limitations. All right, let's go to the second one. Expert witness. So this is a medical claim under Chapter 74. I did instruct you to provide an expert witness. That deadline has come and gone. Why should we not dismiss your case for you failing to provide by the statute?
You know, I did, Your Honor, as a normal citizen, I didn't come to this court as a malpractice attorney.
I appreciate that, Mr. Tagnella, but at our last pretrial, I instructed you clearly that you are bringing a medical claim, and as a result, a medical expert is required, and that's not something I can waive. It is Texas statute. You have not provided that.
Correct.
Okay.
I completely, Your Honor, I did not file an expert report, and I'm not going against your April ruling that Chapter 74 applies, which is why the court may have no choice but to dismiss the claim today. My focus was strictly on the statute of limitations and the equity of the attorney's fees, Your Honor.
Okay. Mr. Tagnella, I appreciate that. I'm sorry that you've experienced trouble with the crown. I think dental pain and maybe stomach sickness are some of the worst problems that anyone can ever have, right? So I hope that you are in a better situation. Because of the statutory limits, though, there really is no discretion left in this one. So it would be a judgment for the defendant. The case would be dismissed for both reasons. One, there's a statute of limitations issue, and then a failure to provide the expert witness. But I appreciate I very much appreciate Mr. Tallahanny here. Though the statute does allow the award of attorney's fees, he's not seeking that. And Mr. Tagnell, I think that's probably an equitable outcome for both sides. I will
Sure.
highlight, though, that technically both sides have the right to appeal my decision, and that does exist for at least 21 days. All right. But we will say judgment for defendant, case will be dismissed for statute limitations issues as well as failure to provide the expert witness. But each party will bear their own costs. Okay.
Thank you, Your
Thank you
Honor.
very, very much. Good luck to each of you. Mr. Tugnell, I hope you have no future problems with any of dental work. Truly. Eeh.
Thank you, Your Honor.
Mr. Tallahanny, I hope you have no issues with dental work. I don't want anyone to have problems with their teeth.
Thank you,
There's no
Judge.
greater
Doing what I do, I know all the good doctors and dentists. I also know all the bad ones. So I try to stay away from the bad ones if I can.
All right. Well, thank y'all very much. All parties are excused. We do appreciate it.
Thank you, Judge.
Thank you, Your Honor.
Thank you. And court apologizes for the confusion with our Zoom link.
And Judge,
We are-
one question.
we
Do you know
process.
when that order would that be emailed to us or will it be
Yes, it will,
uploaded?
Mr. Tallahanny. I'll take care of it this morning. We'll get it processed. We've got a pretty long docket, so you should receive it this afternoon, kind of mid-afternoon.
Thank you very much. Appreciate it.
Thank you both very much.
Bye.
Thank you.
All right, our next matter is also a motions matter. This is cause CV 26000937. This is Stephen Altobello versus Tommy Muller. Do I have someone here on behalf of the plaintiff, Stephen Altobello?
No, I'm sorry. Can you hear me, Your Honor?
Yes, are you Mr. Altobello?
Yes.
Okay, I see you're appearing as Scuba's iPhone 16, just making sure.
Correct.
All right.
Correct.
Do I have someone here on behalf of the defendant, Tommy Muller?
Yes, I'm here, Your Honor.
Good afternoon to you both, or good
Thank you.
morning. It's Friday. I guess I'm eager.
Mhm.
All right. Thank you both for being here. Now, Mr. Muller, we're here on defendant's motion both to transfer and a motion to dismiss. All
Yes,
right.
Your Honor.
Well, the motion to dismiss seems the most paramount, so let's talk with that one first. What would be the reason for a dismissal? What's the cause?
There was actually four. The claim was directed at an individual when the agreement was with an LLC originally. The file was claimed in the incorrect court because everything took place in Harris County back in 2019.
Okay, that's transfer. It's in Harris County. So you're saying that all of the actions accrued in Harris County?
Yes, ma'am. And
All right,
then
where do you reside, sir?
Harris County, Houston, Texas. And then thirdly, the plaintiff was paid in full. It was a $16,000 loan, and he received $26,524.
All right.
That's
Let's
incorrect, Your
stop,
Honor.
Mr.
Yeah,
Altobello, Mr.
yeah.
Mueller, let's stop right there. The motion to transfer is paramount. If I don't have the right to hear the case, I can't make any decisions about whether it's a motion to dismiss or not, okay? So, Mr. Altobello, here's my 2 questions for you.
Sure.
Mr. Mueller says that he lives in Houston. Is
Mhm.
that correct?
I believe so, but
Okay, so
according
defendant
to the
does,
court, when I initially filed, I was instructed to file in GP3. So
okay.
basically, I was just doing what the court was telling me to do. I live in
Court,
Travis
Mr.
County.
Altobello,
Yeah, go
Mr.
ahead.
Altobello, you have 2 options as a plaintiff, no
Okay.
matter what. You can only sue in the court where the defendant lives or the court where the action arose. So if Mr.
Okay.
Mueller lives in Houston, the only other way you get into Travis County is if the action occurred here. What is the reason you're suing him about?
That's still an outstanding debt. So I was just doing what the court was telling me, Your Honor. I don't care where, we do
All right.
this court case, but the fact of the matter is there still is an outstanding debt. There's a contract in place that proves it.
Sounds like there's a dispute
I
about
was
whether the
paid,
contract's
yeah.
paid in full. I got you.
Okay,
I've just
right.
got to determine whether I can hear the case, Mr. Altobello.
That's fine, yeah.
Really,
No,
Mr. Plaintiff,
whatever, like I
contract was
said, from the
signed for a
beginning, I
loan
was instructed
with
to
a
do it in
unified truck.
GP3. So,
I appreciate that, and there's no harm, right? If you're in the wrong court, we would transfer it to the correct court in Harris County. It wouldn't
sounds
cost you
good.
anything, and you just have a
Okay,
different court than to work with. All
sounds
right,
good, yep.
all right. Mr. Mueller, do you by any chance happen to know the justice court that is for where you reside?
I do not.
What's your, well, I don't want you to tell me live because we are in a large docket, but do we have the address that you were served at on,
Yes,
it's
ma'am.
77065. Is that an accurate address?
Yes, ma'am.
Okay, court will take a look and we'll determine which justice court that is, and then we will grant the motion to transfer. Mr. Mueller, your motion to dismiss will still be pending, but that would be before the new court, because that's actually would have authority to hear it. Since you shouldn't be in my court, I can't do anything about it. All right?
And all that will be transferred to the new
That's
court?
correct. So Mr.
Yes, ma'am.
Altobello, Mr. Mueller, everything that y'all submitted to us, we will prepare and transfer to the other court in Harris County, and we will both send you a notice that says your case has now been transferred and give you specifically to this justice court in Harris County at this address. And you can then contact them about scheduling a hearing or motions to dismiss, anything you'd like to be pending. Okay?
And that will all
Sounds
be
good.
via email?
Yes, we'll send everything via email.
Thank you.
All right. Court will determine precinct, and then we will send that transfer.
Sounds
Thank
good.
you.
Thank you.
Parties are excused. Y'all have a good morning, or have a better morning, and enjoy the holiday. Okay. Also, we gotta remember, Brochet, in Harris County, they have multiple places within each precinct, so we might need to call and say, which place do we send it to? I know, that's a fun one. I got a little tag for it, though. But easy enough. All right. I think that does resolve our motions, and now we're gonna get into our actual contested hearings. Yeah. All right. All right, our first contested matter of the morning will be cause 25-2293. This is Heather N. Carl versus Gustavo Artaza. And do I have someone here on behalf of the plaintiff, Heather Carl?
Yes, present.
Good morning.
Morning.
And do I have someone on behalf of the defendant, Gustavo Artaza?
Yes, I'm here.
Good morning.
Good morning.
All right. Ms. Carl, I understand. I believe you're seeking back the return of your security deposit. Is that correct?
Yes, I am. In addition to $1,150 worth of items, the plaintiff agreed to purchase in the home.
All right. Let me go ahead and swear both of you in. Ms. Carl, Mr. Artaza, if you both raise your right hand. You understand that by appearing in court and offering testimony, you are swearing and affirming to tell the truth, the whole truth, and nothing but the truth under a penalty of perjury. Do you so swear?
Yes.
Yes.
Okay, fantastic. Sworn in. All right. Ms. Carl, when did you become a tenant with the defendant? When did the lease begin?
Well, there are 2 leases. The original lease was in August of 23, and then I signed an additional lease for the following year.
So you renewed.
I renewed.
Okay, and then when did the lease end?
The lease was supposed to end on March 31st. However, the defendant sent me a text message inviting me to leave early if I wanted. It was a relatively hostile.
So Ms. Carl,
Yeah.
you had a lease that began in August of 2023, and it was a 12-month lease. What was the term?
It wasn't a 12-month lease. It was a bifurcated agreement where I could leave at the end of March, or if the house did not sell, I could continue to live there until August of the following year.
So was it a 6-month lease?
Well, I guess it went from August through March. I'm not sure how many months that is exactly, but
So your term of your written lease was August of 2023 through March of 2024.
correct.
And then you signed a renewal, and the renewal, did it have a timeline on it?
Oh, that was the renewal. The first one was a year. The first lease, the 2023
You
to
were there from
2024 was-
August 23rd to August 24, and then you signed a renewal through March of 25?
Yes, that's correct.
Okay, so now you have a renewal that allows you to be there through March of 2025. Did you
Or-
end up moving out before then?
I did because the defendant
Yeah, I don't, Ms. Carl, I
invited
don't
me
know.
to move out.
I'll let you tell me why. I just want to know if
Okay.
you did move out earlier, right? When
That's
did you
fine.
move out?
I moved out on March 1st.
Moved out. So you just moved out a little bit early. You moved out essentially the first of the month and not the end of the month.
Correct.
Okay. Did you and the landlord in writing make any agreement about you moving out earlier than the lease anticipated?
Yes, he sent me a text message that I believe I included in my filing that said, "You're welcome to leave early if you like." He was putting the house up for sale. We agreed it was perfect for them to be able to take the photographs with the house staged. And that if I left early, it would be good because then people could see the house empty and they wouldn't have to have a 24-hour lead time to see the home. So I stayed until they took the photographs. Gustavo actually helped me pack up some of my things. He wished me well in a text message. It was sort of a bait and switch, Your Honor. He invited me to leave early. I did it to accommodate him. And then after I left, he informed me that he would not return my deposit because I left a month early. And I was
Ms. Carl,
stunned.
when you got a text message from the defendant that said you could leave early, what day was that text message?
That text message was sent in December. I can tell you-
2024?
correct.
All right. And did he give you a date, or did you just decide to be March 1st? How did that date come up?
Well, when he showed up on February, I guess it was on January 20th, he arrived with his real estate agent. And that was when we talked about my move out date being March 1st.
All right. Was there any discussion about rent for the month of March?
No. No, I mean, I was doing him a favor. So the lease, however, does say that the deposit cannot be used for the last month's rent.
That's right. But you moved out on the 1st, correct? Did you have any discussion at all prior to deciding to move out about where you, and whether or not anyone owed rent for the month of March?
No, there was not any expectation that there would be rent.
That's not the question I asked, Ms. Carl. What you're saying is you didn't expect to pay because you were leaving. What I'm asking is if either of you in writing said nothing is owed for that month.
No, only discussions that we
Got
had
it.
at
So
the house.
you did not in writing confirm that you didn't owe money. You just took it as an assumption because he was wanting you to leave early because he was trying to sell it, so you left.
We did
Right.
have discussions, but nothing in writing.
And that's the problem because your written lease requires you to do things in writing. So that may be the greatest information you get out of this whole thing is, especially when dealing with your housing and that much money, making no assumptions. All right. Now you did move out on March 1st. Did you have the landlord come out that day and do an inspection with you on site?
I asked him, I requested, he said he was coming, and at the last minute he didn't, but he did after the fact and said that the house was in great condition.
But no one was there with you on the day you moved.
He did not come on the day that I moved.
Okay, so no one from landlord wasn't present on the day you moved. How did you return the keys?
There was a lockbox. He asked me to return the keys by putting them in the lockbox.
Okay. Did you take any photos or videos on the last day or the last few days that you were in the unit?
Yes, I took an extensive video of the entire home,
What day did you take that video?
5 minutes before walking out the door.
So on March 1st?
Mhm.
Okay. All right. What type of apartment? Is this an apartment? Is it a home? Is it what type of unit is it? It's a home?
Family home.
How large is the home?
About 5,200 square feet.
Oh, that's pretty nice. All right. What's the bedroom and bathroom breakdown?
I believe it's listed as 4 bedrooms and 3.5 baths, perhaps. Yeah.
All right. And what was the monthly rent?
It was $49.50 per month.
Did you pay a security deposit?
$4,500.
Okay, so the deposit was a bit less.
Well,
Was
that was because it was from the first lease.
Oh.
And
Oh, and then the rent went up at the renewal.
right, and even though in the first lease, it said that my rent could not be raised more than 5%, he raised my rent 10%. And, you know, I agreed to pay the extra 10% because my mother had just died. I didn't have anywhere to go. I just had to do it.
Ms. Carl, was there any portion of the lease that said the security deposit was non-refundable or that there was any additional fees due at move out, like a cleaning fee or a pet fee or?
No,
Anything?
I paid $1,000 to have the house cleaned.
No, I know, that's not what I'm asking, Ms. Carl.
No, none of
Does
that.
the lease say that the landlord gets to automatically deduct for anything?
If there was anything wrong with the house, yes, he can
I'm
deduct.
not, I understand about things that are wrong, but sometimes I see leases that say you automatically, no matter what, agree to pay a $300 cleaning fee.
Yeah.
That's what I'm asking. There's nothing that should have been deducted unless you left it damaged.
Correct.
Okay, so you were expecting to receive your full $4,500 back. All right, so you moved out March 1st, you took a video, you put the keys in the lockbox, the landlord didn't show up that day. Did you provide the landlord with a forwarding address where they could send you your check and your itemization?
Yes, I did.
When was that done?
I wasn't sure where I was going to end up living, so initially I asked him to Zelle the money to me, but on April 9th, I did provide him a physical address.
So a month after you left, you gave him your address.
I gave him a physical address.
Great. And after that, did you receive an itemization or a refund by May 9th or May 10th?
No. I did receive a check on July 28th for $275 that I returned to Mr. Artasa because I was afraid if I cashed it, it would mean I was agreeing to his terms.
All right. So Ms. Carl, between May 10th and July, did you receive any information from the defendant about the security deposit?
No.
Any communication from him at all?
Just simply that he didn't owe that to me.
When did he tell you that?
I believe it was, the first mention of that was the day after I moved out.
Ms. Carl, you moved out and you gave him a new address on April 9th. After you gave him an address, did he at any point through text message or email or phone call say to you, I'm keeping the money?
Yeah, from the day that I moved out, he continued to say he was keeping the money. Up till today, actually.
Ms. Carl, what I'm trying to establish is whether he gave you any form of an itemization after you left before he sent you a check in July. Did you get anything from him at all that said why he was keeping the money?
Yeah, the only itemization, which was well after the 30-day time frame, was
When
that
was that?
I think that was sometime in July.
So when you got the check.
Yes.
So is it your testimony, Ms. Carl, that you received no information of any type whatsoever from the defendant in the month of May and June related to your deposit?
Correct.
Defendant didn't say anything. He was silent with you in the month of June.
No, I'm not saying he was silent. What I'm saying is that from the day after I moved out, I continually texted him and said, let's try to resolve this, amicably. I left the house in really good condition. I staged it beautifully for you as, so that you could sell it. I've tried to be accommodating. Let's not do this.
He told you he was keeping your money from the get-go, though.
Plus, from the day after I moved out.
All right. Let's just move to Mr. Gustavo. Mr. Gustavo, why'd you keep all the money?
Because we had the agreement, a lease agreement that was through March 31st.
Did you send her a text message and tell her she could move out March 1st?
She asked me if she could move out earlier, and I told her, yeah, if you want to move out earlier, that's fine. If you want to move out earlier, and I left it at that because I can't force her to stay there, but her agreement goes through the end of March.
All right, so she moved out. Did you go and inspect the property after she left?
Okay,
on the
so you
1st?
asked me the question, and so what? This all occurred around, I think it was like, I think around September, something like that, October, and she was wanting to. She said, Gustavo, I told her part of the agreement of you being able to stay there is that I would go ahead and be able to show it 3 months before, and she didn't really want people going in there. And so that caused a problem for me because I said, that's part of the agreement that we have. So when she told me she was leaving earlier, and that would be sometime, I guess, around January or February, I told her, yeah, you can leave if you want to leave earlier. But then I went over to her house 2 days later and I said, listen, if you want to leave earlier, I can't force you to stay here, but you're responsible for your lease payments through the end of March. And she
When
says,
did
well,
that
I can't,
conversation take place, Mr. Gustavo?
sometime in late January, early February.
Go ahead.
And so I said to her, she goes, well, I can't do that. I've already arranged for the trucks to come here. I said, I get it, but you're taking out of context that you can leave early to the point of I'm letting you leave and break the contract. And I'm not doing that. And that's why
Right, so
two
your
days
position is
later,
you
I
were gonna
went and
charge her
made
for the
sure
rent.
she,
So
I'm
she
sorry.
moved out. When did you give her an itemization?
I gotta look it up here. I think you have all the information there that I sent to y'all.
Mr. Gustavo, it's your case and you're the defendant. I would hope that you would know the day you sent your itemization to the defendant when it's a
Let me
deposit
look.
that large.
Okay, let
That's
me
really
look.
the only question of fact the court really needs to know.
Yeah, let me look. Let me look here. Okay. Okay. Let me see here. Um, here.
I'll take a look at what you sent us, Mr. Gustavo. Perhaps I'll find it faster.
I'm sorry, what's that?
I'm gonna take a look through what you submitted as well. While you're looking,
Okay.
I'll check for you.
Okay.
I see we've got an invoice. I see parts of the lease.
I sent it to her. I would say,
I see,
it's the problem is that I
I see
deleted
a
my,
breakdown that's not dated. I see an email dated May 13th. That's forwarding a message from September of 2025. Where should I send the check for the amount that I owe you after subtracting the month of March in addition to landscaping bills and bills that I've sent you? If you take me to court, I'll ask for a triple as well as a frivolous lawsuit. You can't ask for triple if there's no reason to it.
I know.
Not how that works.
Yeah.
But this is historic proof that you're still trying to send her the money in September. Right?
Well, I sent her the
that email,
check.
Mr.
That's
Gustavo,
correct.
that is an email from you to her in September saying, where do I send you the money? So you have not sent it. And then I have a check that's dated
Because she wouldn't give
July
me the,
15th.
because
But
she would
she
not give
said
me
she
the,
gave you an address in January. I'm sorry. She said she provided you her new address on April 9th. Ms. Carl, do you have proof that you sent your address on
Correct.
April 9th?
Yes, I do.
Mr. Gustavo, any objection that she gave you an address to mail her refund on April 9th?
I did object to her. Yes.
She says she sent you an address on April 9th. Is that true?
Let me look it up. Let me look.
I can share my screen and show you my text messages.
So Judge, if she shows you that, can you have her show you all the text messages that we had?
I don't need to see them all. Mr. Gustavo, Ms. Carl, I appreciate that y'all have a lot of emotions between you about the situation.
Yeah.
But for purposes of the court, I don't. This is a very simple issue. Security deposits are governed by the property code and they're very strict. So there's not a whole lot of whether you meant to or you didn't mean to. It is a fact question. Once the tenant moves out, the law kicks in. It says the landlord must return or itemize the deposit within 30 days of the tenant leaving or giving an address. And it's the later of the two. She moved in March, but she didn't give you an address till April 9th. So she told her timeline until April 9th. But once she sent you the address on April 9th, the statute sticks to you, Mr. Gustavo. You have 30 days to put in writing either a reason you're keeping all the money or a refund. If you don't make your 30-day deadline, Texas law says you have no right to retain any portion of it. She gets it all back. There is no dispute whatsoever on the facts that y'all have shown me that you didn't refund the money to her until at least July. So for that reason and that reason alone, it would be a judgment for the plaintiff today for $4,500, which was the amount of her deposit. All right. Judgment for plaintiff, $4,500 plus cost of court.
Oh, I like to appeal.
You absolutely can do that, sir. You
Mhm.
both can appeal for 21 days. If you want to appeal, Mr. Gustavo, typically the amount would be double the judgment. If you can't afford that, you can ask the court to reduce it, or you could apply for an affidavit of inability. You might also be able to do a surety bond. There's some ways about it. You each have 21 days to appeal. I'll also give you more information. If y'all in the next 21 days come to an agreement with each other, it is not uncommon for parties after they come to court kind of get, the legal answer, which I recognize is not a fun answer. Because like I said, there's plots that have gone on between the parties. You had a 2-year lease. Some of it was good. Sounds like it got stressful toward the end. If y'all discuss with each other in the next 20 days and come to an agreement, the court, you can notify me of that by the end of 21 days and we can set this judgment aside. But you also can appeal. So you have all of your options. You can do nothing. The judgment becomes final on day 22. Either one of you can appeal, go to a new court. If you settle and wish to set aside the judgment, you can do that, but you must tell me together by the end of that 21-day period. All right?
Okay.
Any questions about the information I'm given?
What about the 1150 of items in the house he agreed to pay for?
Do you have proof in writing that he agreed to pay for those items?
Yes, I do.
All right, Mr. Gustavo, did you agree to pay for items that she left behind?
Yes, yes.
Why didn't you pay her for those items?
I did. I took it off of the rent that she owed me.
All right, so she gets that too. So 4,500 plus 1155 because you can't keep the deposit since you were late in itemizing it. That means
I was late in itemizing it.
Yeah, you didn't refund it until July and you had to have put it in the mail or itemized it within 30 days of her giving you her address, and she gave it to you April 9th. So your deadline at best would have been into May. You're way past that when you're in July, sir. Okay.
I need to look and okay, that's fine.
Judgment for plaintiff, $5,655. That's $4,500 for your deposit, and then the $1,155 for items that Mr. Gustavo, you acknowledged that you agreed to let her, you would pay her for. Items owed by the defendant. All right. I don't find in bad faith. I find that you were too low, you were too slow in refunding it, and the deposit statute says you can't keep it if you're so slow in it. All right. All parties are excused. Thank y'all. Have a good morning.
Thank you.
All right, our next case is going to be clause 25-2701. This is David John Moore versus Fold and Go Wheelchairs and I think it's one, oh, okay. Done Cubed Designs. It's just the way it was written down. It looked like D1. Sorry, y'all. Done Cubed Designs, LLC. All right. Do I have someone here on behalf of our plaintiff, David John Moore?
Yes, I'm here.
Good morning, sir. Thank you for being here.
Yeah.
Well, we have two defendants. So do I have first someone representing Fold and Go Wheelchairs?
Your Honor.
Yes.
So, sorry. This is Shelby Hart Armstrong. I'm counsel for Fold and Go Wheelchairs and One Cube Designs. And also the owner and CEO of that entity is Miss Michelle Klein, who is here today. In terms of those entities, so Fold and Go Wheelchairs is a subsidiary. So like an asset of One Cube Design, so they're combined.
All one thing, like a subsidiary brand within One Cube Designs.
Correct, Your
Kind of
Honor.
like a product line you've got. Okay, fantastic. So our
Correct.
counsel is representing both defendants because it's essentially kind of one big defendant. Okay.
Correct, Your Honor.
All right. And then Ms. Hart Armstrong, you said that you did have, do you have a witness or a representative to the owner of One Cube Designs?
Correct. So I have Miss Michelle Klein here today, who is the owner and CEO of One Cube Designs, and then this subsidiary asset, Fold and Go.
Good morning, Ms. Klein. Thank you for being here as well. All
Thank
right.
you.
Mr. Moore, Ms. Kleinson, sounds like you'll both be witnesses. Let me go ahead and just swear parties in that way. We take care of that up front. So if you would raise your right hands. You understand that by appearing in court and offering testimony, you are swearing or affirming to tell the truth, the whole truth, and nothing but the truth under the penalty of perjury. Do you so swear?
I do. I
Thank you
swear.
very much. I always like to get that out. Justice court's a little more informal, so we don't typically just go one and then the other. We get kind of, all right, let's see if we get the facts together. That's why it's good to go ahead and swear people in to begin with. All right. Now, Mr. Moore, you're seeking funds related to the purchase of a wheelchair that I think said is not working correctly?
Yes, Your Honor, that's correct.
All right. How much did you pay for the wheelchair, sir?
It was a total with the $59 as a flat rate shipping of $2,954.
$29.54. All right. When did you purchase the item, sir?
It was purchased 11/29/24.
November of 2024. All right.
Yeah.
Did it come with any types of terms and conditions or a warranty?
A 1-year warranty on it.
And Mr. Moore, where did you purchase the item from? Was it a website or a store?
Yeah, it was a website. I believe it was foldandgo.com.
So you purchased it, to your knowledge, directly from the manufacturer?
Yeah, actually, my sister-in-law purchased it. She used her credit card. I paid her back in full, and it was shipped to my address.
Okay. All right. What specifically are you alleging is defective about the product?
Well, I received it in December. I got a little notes here. I also have my caregiver here because I'm tough with dates. She's kind of my calendar.
Absolutely. That's not a problem, y'all.
So I received the wheelchair in December of, what was it, 2024. And in Minnesota, it's full of snow and ice. I unpacked it. I had limited use with it. I did take it one time to a plasma exchange down at the university. And what was going on right away when the temps were cool, or in that right out of the box, what was going on is when I would drive it with the joystick, get to where you're going to and let go, or that's how you stop a wheelchair. You let go of the joystick. They wanted to nitpick about how I was driving it, but you let go of the joystick, it would instantly pull right, turn right into a wall or into a desk. Then that spring came in summer, then what it was doing as you're driving it, it would just make the same sound as the horn makes when you push the horn button, beep, stop, and then go again. And so that was my issues with it at first. Since now the frame has snapped, which many other people report that the titanium bike frame snaps. And it looks like it broke approximately a week later, in the summer after. So I'm driving it to them appointments in the spring is when I more started using it. I knew better than to try to use it through the ice and snow out here in Minnesota. So, yeah, that's about it. The controller would pull to the right and almost hit a nurse. Was the first time I noticed it. Almost ran her feet over, and then when I called and I explained it to him, the service that was set up was to be a Zoom service call, and it just snowballed and got worse from there. So
Did they have a Zoom call with you?
they had a Zoom call with me with a man named Jesse, Your Honor, and they literally had me out in my yard here where I am now, driving the chair with my caregiver following around with the phone call. And I couldn't even really get a word in with him with this Jesse, because every time I tried, he would just move on to the next thing. He wasn't giving me a chance to show him anything. So,
Were you able to demonstrate the problems with the wheelchair to him?
yes, I did, Your Honor, twice. Once was it's spinning in the wet grass, the tires, and that's part of the issue with the pulling, I believe, because of brake or controller hanging up. And then the other, she just showed me a little note there. The other was coming up the driveway, letting go, it will just turn. I mean, that'll turn right into parked cars. It'll turn into anything upon stopping. There's no right or wrong way, which is, I believe, is what they have mentioned to me on how to stop your power wheelchair. You drive it, and when you get to where you're going, you're done. You let off. You don't pull back. You don't turn right, left. It's there's something hanging up either in a brake or in their controller. That was my original complaint. Now since it's sitting right here, it's rendered totally useless. The frame is broke.
All right,
I'm out $2,900 and I didn't even use the thing.
Mr. Moore, you said that you called the service department and you had a Zoom call with a man named Jesse. Do you remember probably what month and year that was?
Let's see, May of 2025.
Yeah, spring, May, she says of 2025.
June.
It may have been June too. So here's the other problem, and it's believe it or not, since then I've changed phones. So I don't have a call log in my phone.
Fine, sir.
The other, or I could give you the exact date and time,
I appreciate that.
Thank
All
you.
right, but you did call and have a service contact. Were the problems resolved as a result of the Zoom call?
No, I was told, then he claimed as fast as I could explain one problem, he was on to the next thing. He actually asked me with a muscle disease to get out of the chair, flip it over, and show him how the front casters spun around because he wanted to see the wheel bearings spinning.
Maybe he misunderstood why you were needing the wheelchair.
Maybe so. Yeah,
Right.
but so then it went on, and then I said, well, don't you have a service hub here? Anywhere I can bring it, somebody can look at it. No, you'd need to ship it to us. And I says to him, let me guess, I would pay the shipping. Yep, you pay the shipping both ways, and we're probably not going to find nothing wrong with it. That was his exact words.
So you would need to ship it to Texas for repair and it would be at your own cost.
Correct, and the return shipping.
It was still
Did the defendant offer any other solutions or possible fixes?
Not other than to tell me how I'm driving it wrong, how Mrs. Klein is, I don't know if she'll tell you this, how she told me she could load her fold and go up onto an airplane right now, come here and drive through any terrain on my property like well, how'd she say it? Like a monster truck. It'd go right through there. And just that they offered no solution to answer. So
Did you ask if you could return it for a refund?
I did, yes.
What did they tell you?
No, they weren't going to refund my money. And basically they were telling me that it was all operator error. And I know that I can't go by this, but I don't know how many people have brought small claims against this outfit, but I have seen several folding wheelchair site of people complaining of the exact same thing. Exact same. The brake is the same in the frame, the pulling, their customer relationships, the owner who's going to tell you coming up how she has, it's all about her and her rheumatoid arthritis. And she's a person, I'm sorry, I get excited.
That's okay. I appreciate that. I understand. There's always a lot of emotion in cases, but I'm the judge, so I got to stick to kind of the basics of the contract. Let me ask you this.
I get it.
Mr. Moore, you've done a very nice job. You've given me you've had really good information for me that gets me in the timeline here. One other question I had is, at the time you purchased it, or you said your sister purchased it, you reimbursed her and she sent it to you. And so once you got your device, you said it did come with a 1-year warranty. Did you get a written terms and conditions for the warranty?
Yes, I believe I did.
Have you had a chance to review them? Do you see if there's anything in the terms and conditions that would prevent you from being able to get a refund?
There was nothing I've seen. No.
Anything else? I understand
I can't honestly tell you I combed through every inch of the warranty.
I appreciate that, sir.
saying that, but I believe it was how does every place says it, a limited 1-year warranty or a 1-year full warranty, or
Okay.
It just, to me, it's unfathomable that an outfit will not stand by their product. They won't even entertain the idea that there's something wrong with it, and they just rather tell it. I mean, I wish I would have had the phone call because It
Right.
it was all right there. Boy.
Mr. Moore, did you bring any, or by any chance, and I don't know that you would, but do you have any exhibits? Did you have any video that you wanted to show me, anything at all?
Well, I had sent in a picture of the chair. I don't know if you can see this. This is the break. This wasn't even why I smiled or filed those small
Let me
claims.
take a look, sir, because like that's a little bit hard with the Zoom. It gets blurry as
Okay,
you come in
yeah,
and out. So let me
and I did send that.
photo.
in.
Let's take a look.
Break.
Okay, I see that photo, sir. I'll share my screen and that way it's a little clear. That way defense counsel can
I
see it
got
as
where
well.
the break is.
Yeah, she can see.
Okay.
She's sharing it.
So this is, Mr. Moore, I'm sharing my screen now. This is a photo that was submitted by plaintiff, an exhibit submission. And so is this a screenshot or a photo taken of the device?
Yes, it is. That's the back of the chair. I have the chair sitting here now, and that the bolt that you see there missing the nut is I took it apart to show. Well, actually, Donna here did, my caregiver, to show the brake, because if it's back together now, and if I was to show you this, and I can with my iPad, it's not apparent to you where the chair broke once it's bolted back together. It cracked right there, right through the whole tube.
Okay.
Like many other people's have done, and they just refuse to. I don't even know if they're aware of the break in the frame right now today, but they were aware of the controller problem, the pulling, the stopping, you know.
Oh.
And they also, Your Honor, and I asked them this, and we didn't have the most friendly conversations, and I'm guilty of that because I'm almost $3,000, and they refused to stand by it. But they had a video up on their website, and I know for a fact they did. My sister-in-law sent an affidavit notarized to you, stating she's seen it, of a gentleman, a big guy, riding one of these chairs through about maybe trying to get in maybe that much mud. Just no problem going right through there. And when I asked about it, within hours, that video was gone. They took it right down. It's not there. If they can provide it, I'd like them to tell me where I can find it and see it again, because it's not there.
Mr. Moore, thank you. You've given me good information.
Thank
Let's hear
you.
from the defendant now. All right, Ms. Hart Armstrong, thank you. I don't know if you would like to call a witness or if maybe counsel wants to raise issues immediately, but I'd like to hear from them.
Or you think is most efficient, Your Honor.
Are there any contractual issues that you're going to raise, right? Because I've got right here is a product defection. He's wanting a refund.
Yes, Your Honor. So we submitted into evidence the return policy as well as the terms and conditions. And I'm happy to show that. I'm also happy to.
So that's my question is the defense that the policy says he doesn't get his money back because it's too long, or is it works and he's just incorrect?
So it's both. So first there's the return policy, which is a 30-day return policy, which is published and provided to customers of the Fold and Go wheelchair. And just for timeline sake, Mr. Moore's acquaintance or sister's friend purchased the chair in November of 2024. The chair was delivered to him in December of 2024. Shortly thereafter, he did not contact Fold and Go until June 2025. And we have in evidence, which we submitted, I'm happy to share with you today, multiple order notes, which are like business records maintained by One Cubed and Fold and Go, which reflect the conversations that Mr. Moore describes. So he got the chair in December, 6-month time lapse, calls in June. There are multiple conversations and calls that happen. The first one is with an employee technician at Fold and Go. He explains like the purported issues with the wheelchair. The second is a video call where the technician then gets on a video call with Mr. Moore and tries to resolve the purported issues, which I can get into further. And then the third is Ms. Klein, the founder of the company, then calls Mr. Moore to try to resolve the issues. So in terms of the return policy, I mean,
the resolution is simple, Ms. Armstrong, with respect. He wants his money back. The defendant is saying, no, he only had 30 days. He missed his window, tough crap. And that is the answer.
Sorry.
That is the answer. The law says our contract that we signed you, our product policy says you have 30 days to get a refund. You didn't make it in 30 days. If you want to ship it to us, we'll try to repair it. He doesn't want to pay for the shipping cost.
Correct.
And that's it. It's a very simple, our contract says no, we're sorry, but no, we're sticking to the contract.
Correct, Your Honor.
Okay. Mr. Moore, how would you respond? They said that the contract and terms and conditions say you can only refund it within 30 days for a full refund. You have to return within 30 days.
Oh, Your Honor, I had contacted him within the 30 days because it was shortly after that very first plasma exchange that when I went down to the U, I can look on it and find the
Mr.
exact
Moore,
date. I did.
did you return it for a refund within 30 days of receiving it?
Did I return? You mean ship it to them? And no, because to be honest with you, I wouldn't even have got it to them. They couldn't have gone through it and shipped it and answered me in 30 days. Their answer was, ship it to us. We're not going to find nothing wrong with it anyways.
But that was after you called them in June.
Right, that's when that was.
That's,
But they did get a
that's my
call
point, Mr.
prior.
Moore, and that's the defendant's point.
You did
By the
call.
time you contacted him in June, you'd already missed your window for return. The only time you could have returned it for a full refund would have been within the month of January, or actually the month of December, because you got it 1st of December. Now,
Okay.
Mr. Moore, I don't disagree. That's not a very equitable outcome for you. You got to, at your expense, ship back a very, very heavy device for which you've spent $3,000, and you're going to have to spend, I don't know, several $100s in shipping fees. But the fact that it's unfair doesn't make it illegal because they told you that up front when it was purchased. And that is a horrible part of buying things out of state. I have encountered the same thing with the very large device that you had to ship it because they only have one repair spot. Living in Austin, people with a Tesla can't stand it because there's only so many places you can take a Tesla for repair,
Right.
at least until they build more. So in terms of a refund, the policy is clear that they require 30 days, and you did miss that. After that, if they are offering to repair it, it is at your expense, and the court can't make them pay for it if the contract and its terms and conditions up front says that it's at your own expense. It is just
So,
unfair, but not unlawful.
right. So, Your Honor, just so I understand it, what you're saying is if I ship this back to them, then they can repair the frame and the joystick on it.
I
I'll
don't
say
know
that-
that. Are you still within your repair deadline? I think you had a 1-year
Well,
warranty.
by now, the court, the whole thing, yeah, when the complaint went down and the service calls went down, yes, I'm within that deadline. Easily within that 1-year warranty of theirs, right?
You received it in December of 2024, so the 1-year warranty would have run in December of 25. Ms. Armstrong, I understand that legally there's arguments to be had here. I'm just curious. Any response that y'all would give to Mr. Moore if he was still seeking repair?
So, and I'll be frank. I saw that he submitted a couple days ago photos of the chair, and there does look to be, and I don't know when it happened, a missing bolt. And part of the publications talks about service maintenance and hand tightening bolts and maintenance required for the bolt. We talked about, I guess Ms. Klein indicated a willingness to get the chair and repair it, but there is a concern about if we're not legally obligated to do so, him returning the chair, her working on it, and then opening up liability if it's not maintained in the future.
Okay. Mr. Moore, I think everything Ms. Hart Armstrong just said is accurate and understandable from a legal perspective. And I think this is a case where the legal answer is not the answer that probably feels very good, and certainly not an answer that would make you feel better, Mr. Moore. I recognize that the difficulties and the frustrations you're experiencing, and certainly I definitely understand the hassle with the cost to ship something back at your own expense for something that didn't work when you got it. But that inherent unfairness is not in itself, it's not illegal, especially if it's upfront that it's going to be at your own cost to send it back. So for those reasons, both the lack of the ability to refund would have been within 30 days, and that did not occur. And the 1-year limited warranty, we've missed that deadline as well. I don't hear that there is a cause of action that we would sustain any damages for you, Mr. Moore. Today it would be a plaintiff take nothing. I'll leave you with this.
Okay.
You have the right to appeal. Also, Miss Armstrong or Miss Hart Armstrong and her client, Miss Klein, they at least have said they might be willing to talk to you, although albeit they've said there are legal concerns they have. I'll just say that there's nothing that prevents parties from talking to each other after the case is over. You both have a right to appeal. But with the information I've received today, Mr. Moore, it is going to be a plaintiff take nothing. I'm sorry.
Yeah, and Your Honor, back to her, just so if it's okay, I respond to her. I knew that was coming, the whole tightening of the bolts thing. This is what they preach to everybody, okay? So number one, when that arrives here in December, in the winter, and then the dead of winter in Minnesota, and I realized that's when I purchased it, that's when it arrived. Number one, I've tightened them both 2 times since this thing has sat here the whole time broken like this. I tightened them both twice. I never even used it. So her whole theory about you tightening these bolts, I knew it was coming. I told it to my caregiver. They're going to point right at that bolt and she's going to say you don't tighten it. It's unbelievable to me that Texas or anywhere in this country can let an outfit like this go around selling chairs like this to people. You open a folding wheelchairs. I know you can't take, I don't mean to point. I know you can't take that into consideration, but all them photos and all them emails that were sent to you, and they can sit back, her client and her lawyer right now and smile knowing they won, that's fine. If they want to cheat people who are cheat, she makes wheelchairs. I'm a wheelchair person who makes them for people. They're conning people. They're preying on people, and they're finding out prescriptions and junk, and it's breaking. And I'm not the only one. It's full of it on this, the exact same problem. I'm the only one I think that have brought them into court. And you know what? They get a worm of a lawyer like that. They wiggle out of it.
Mr.
And
Moore,
the justice system is
Moore, I
horseshit.
appreciate
It's
you're
horseshit.
unhappy, but we
Yeah,
don't need to
well,
call
it's
names
nothing
parties.
for me, so
Okay.
I'm done with it. Thank you very much and goodbye. It's
Very best
nothing
of
for
luck to you,
me.
sir.
They might find it in their parking lot one day. That's all.
Mr. Moore, very best of luck to you. Thank you for your time. All parties are excused. All right. Get back here to my docket. Thank y'all. All parties are excused. Our next case will be for cause 2-6. Actually, it is 10:20. Shay, would you like to take a short 10-minute recess?
I'm fine, Judge. It's up to you.
All right, no, I'm bored. I try to be reasonable with my clerks. I like to work through my docket, and then I realize she's like, "Hey, Judge, I want to grab a soft drink or use the bathroom." So, sorry, y'all. I get on the bench and I just want to go through my docket. All right, then our matter that we're kind of come to is 26121, and this is Camila Ramos. We have 2 defendants. So first we have Alexandra Tate Cutler, and then we have a DBA Alley Tate US LLC doing business as Unfuckwithable. Do I have someone here on behalf of the plaintiff, Camila Ramos?
Here, Your Honor.
Good morning, Ms. Ramos. Do I have
morning.
someone on behalf of the individual Alexandra Tate Cutler?
This is Brian Levy on behalf of Alexandra Tate Cutler.
Good morning, Mr. Levy. And
Good
then
morning.
are you also representing the DBA Alley Tate US LLC?
Yes, I am. And it's actually not a DBA.
Is it an LLC?
Yes.
All right. Let me go ahead. And do you have anyone as a representative or a witness on behalf of the LLC?
Yes, we have Alexandra Tate Cutler here.
Okay, so Ms. Cutler's going. All right, let me go ahead and swear on all parties. And Mr. Levy, if you're going to do any testimony, I don't know if you're seeking fees. I think we have a counterclaim in this one, don't we?
Yes, Your Honor.
Okay, all right. If I could have parties and witnesses raise their hand, I'm going to swear everyone in. Thank you for appearing in court. By swearing today and offering testimony, do you swear or affirm that you will tell the truth, the whole truth, and nothing but the truth under a penalty of perjury?
Yes.
Fantastic, sworn in. All right. Ms. Ramos, why are you seeking, or why have you sued the defendants, and what are you seeking?
Yes, thank you, Your Honor. So I am seeking the commissions that I was owed, in short, for my work as an independent contractor commission sales closer. And I'm also seeking a refund. I was also a client of Ms. Tate's in the program, and I'm seeking a refund of what I paid in the program. And I'm also seeking legal fees that were related to the counterclaims that Ms. Cutler brought up during the filing of this case.
How much are you owed for commissions?
So for commissions, it's 11,062 and 72 cents. And I also want to add, I had another role in her company as a coach. It was very short, but so I'm also asking for the $400 that I was owed for my work as a coach.
All right, and how about a refund of services?
4,410, excuse me.
All right, and have you had any out-of-pocket legal fees other than your cost of filing in court?
Yes, I had, I received legal notice from Brian Levy in Treaty Oak Law Group, and I engaged with an attorney to respond, and it was a $1,500 retainer, of which the other than $158 has already been used of that 1,500, and the 1,500 is non-refundable.
Are you represented by counsel?
I'm not today.
What did they do?
So Treaty Oak Law Group sent me a legal notice, and initially, this was obviously before we filed here. So initially I engaged with counsel to respond. So they responded to Treaty Oak Law Group regarding their allegations. And moving forward, I couldn't afford to go out of pocket for an entire court process. So I decided to move forward pro se.
So you incurred that expense prior to you filing your lawsuit?
Yes, Your Honor.
Okay, and that was, you said about $1,400?
15.
But they still have 189 remaining?
153.
Okay, so.
But it's not, the 15 is non-refundable, but it's okay. I'm happy to. It's a non-refundable retainer.
Who'd you hire?
Deshino and Shami in Florida, and I have their invoice as well as the itemized. I live in Florida.
Oh, that explains it. Okay, all right. Okay. So commissions, coaching, refund, legal fees.
Correct.
When were you, you said that you were an independent contractor, you did sales work for the defendant, is that correct?
Correct.
When did your working relationship with the defendant first begin?
I was approached by Ms. Cutler sometime in August of 2025, and my first sales calls began at the beginning of September. I believe September 3rd or the 1st, if not.
When you met with her in August of 25, did you in writing confirm what the agreement was going to be for how you were going to be compensated?
There were text messages exchanged, and so we did confirm. Initially, it was a 10% commission paid as she collects, and then we had a few recorded calls where we continued to exchange the terms of my responsibilities and the steps and hers, and then
was there
there
any
was also
type of formal independent contractor agreement signed between you and the defendant? So is there anything formally illustrating when to be paid, what happens if things go wrong? Or is there anything other than a sort of casual text message creation of this? Okay, so we've got a very loosely based contract for work. It was going to be paid as the defendant collects. What if she never collected?
Correct. So part of my responsibilities was to set up the clients with their credit card payment and to set them on auto pay. And the reason why I agreed to a pay as collect is because Ms. Tate also had a responsibility in to send the clients their own contract. In that contract, there was a non-refundability clause as well as a responsibility to pay for defaulted payments. And that gave me the confidence to accept a pay as collect term in my own engagement.
But y'all didn't actually discuss what happens if she doesn't pay, if she never gets paid.
Correct.
I mean, the answer is if she doesn't get paid, you never get paid.
Well, she does have that documentation
I know,
with the clients.
I deal with people
that
who
was an
promise to pay all
assumption.
the
Sure.
time. There's a reason courts exist, right? So the fact that she says I'll pay you when I get paid means if she never gets paid, you never get paid. No, that is the answer. If it is a conditional statement, it requires a condition to be completed. Okay, so your commissions are based upon her collecting the money. You're going to get a 10% of that. Did you provide the bills to her so that you could calculate the 10%?
Correct. And I want to be clear at a certain point on September 30th, prior to the month completing, we had a recorded video call where Ms. Tate changed my commission rate retroactively for that month to 17%
So for the
because
month
of my performance.
of August or September?
September, which is when my calls began.
Okay, so it was gonna be 10% when she recruited you, but then you actually had a great first month, and so she said retroactively, I'll pay you 17%.
Correct, based on a sales threshold that I met.
Was that something y'all had discussed in August?
No, what we had discussed in August was certain payment expectations. I brought up to Ms. Cutler that what I was receiving fell short, even though I was performing beyond the expectations. And so that was her way of fixing that.
Were you not getting 10%?
Well, I hadn't been paid yet, but I was doing the math, and she had given me numbers of what I can expect based on the price of her course and based on certain close rates. And I was showing up to the calls, getting those close rates, and the math was off. I think it was just.
Okay, here's another question, Ms. Ramos, because this is going to go into what Mr. Levy's answer is. Who did you have your communications with in these text messages? Were you talking to Ms. Cutter, or were you talking to Unfuckable? Or I'm sorry, Unfuckwithable. Let me be clear about the name of the defendant.
I was speaking, I mean, it was a text message with Ms. Cutler.
This is an important
was,
part of the case, Ms. Ramos, because Mr. Levy says
I
that you're seeing her
understand.
incorrectly. So you got to tell me, were you talking to her as a individual, Ms. Cutler, or were you talking to her, Ms. Cutler, owner of an LLC that was hiring you to do sales work?
I felt like I was speaking to an individual because Ms. Cutler is the face of her business. She's the sole owner.
But it
And
was the
also,
face of a business.
Mhm.
So you weren't talking to just a woman named Ms. Cutler. You were talking to Ms. Cutler, who owns a business.
Sure. To be clear, my filing, because Ms. Cutler resides in Texas, my filing was in Texas because when I first searched her Alite US LLC, it didn't show up on the Texas Secretary records. So my filing was her individually solely because I couldn't figure out where her business was located. It wasn't until February that she actually filed with with the Secretary in Texas, like put her business, which is apparently in Delaware, was then filed to be able to do business in Texas. It's not, I don't know if what I said was clear.
Yeah, no, that's actually very common. So now my question then is, Ms. Ramos, it sounds like you sued her as an individual because you didn't know how to find her company. Now that you know how to find her company, are you wanting to still pursue her as an individual, or were all of your interactions with her is her role as owner of an LLC?
Your Honor, I don't have a preference as to whom the filing is for. If it makes sense for her to file the company or for her individually, I'm okay. I just want what's owed to me.
Ms. Ramos, that is a legal question that I cannot answer for you. It is a distinction in who you're pursuing, and
I put both. So
all right. That's good information. All right. All right. So you did have interactions with Ms. Cutler. You knew that she had this LLC. Originally, when she recruited you, or when y'all were discussing it, you were going to start getting paid commissions at 10%. And did you also sign up for a class at that time?
no, I was a client of hers prior to that time.
So you knew her before this communication in August.
Correct. So I was initially a client of hers,
When
and
did that begin?
April 16th was my official start date.
When you say you're a client, what classes were you taking?
So Ms. Cutler had a program that included group coaching as well as access to a platform and a community. And so I would show up to the group calls and watch the recordings and communicate with the members of the community for how to build an online digital business.
And you began that in April?
Correct.
All right. How much did you pay? Was it a one-time flat fee, monthly?
I paid a total of $44.10, and that was split over 4 payments.
But what'd you sign up for?
$44.10.
So it was a package. It was all one flat price.
Correct. Yes, correct, Your Honor.
All right. And was there a specific set of information, like you're going to get these things as a result of paying $44.10?
Not in writing. I never received an actual like a client agreement. It was all through a video with one of her closers at the time. But
Did
yes,
the
it was
video lay out what
access
you
to
were
the
gonna do?
program. Yeah, the access to the group calls and the program and the community
How did you pay the 4410?
with a credit card.
Okay, and did you get receipts for those?
I did, and they're part of the exhibits.
Did you get any kind of agreement in writing or a contract that says here's what you're getting for 4410?
No.
Anything at all?
No, just the access to the platforms.
What's the platform?
It's a website called School, and Ms. Tate had her program on that website, and I was invited into that program, and also links to Zoom calls where Ms. Tate hosted group calls. And then part of that was also community and being able to engage with the other women on in the platform and the community that had similar aspirations and wins and struggles and things like that.
All right.
That we could all.
You signed up for a class in April of 2025. You paid $44.10 for that. You participated in the class, and in August, a few months later, the defendant approached you about working for her, and you agreed. You said, I will do that, and you'll get 10% when she gets paid. You did a month of work. Your work was better than expected, but you were not making the money you thought you'd get for what you heard from a class. So the
No,
defendant,
from what I heard from Ms. Tate, excuse me, I don't mean to interrupt you, Your Honor. From what Ms. Tate said in her original offer.
what she pitched you would be able to earn, you weren't really earning it that much, which is, not uncommon. People say that all the time.
Sure.
But she said, all right, well, I'll pay you 17% instead for the month of September.
Correct.
And as a result of that 17%, what were you supposed to be paid in September?
So it was as collected, and I have an exhibit that shows each month. So that shows all of the clients, the calls, what I collected for each month, and then the payment plans that I would put them on. So some clients paid in full, some would pay a deposit, and then there would be payments over the next 4 to 6 months, some 12 months. And so I have a spreadsheet of what those numbers should be and what the 17% commission should be from that.
Have you received any payment from the defendant for work you performed?
Yes, I received a payment for 17% on October 2nd, and that would be Exhibit A4, which I also submitted.
How much money has the defendant paid you so far?
$4,139.50.
All right, and what do you claim she still owes you? That's the 11,062?
Plus the 400, yeah.
Plus 400 for coaching and then the refund. All right. Have you provided an itemized list of the breakdown for where the 11,062 comes from?
Yes, Your Honor.
Mr. Levy, is there any portion of the unpaid commissions that defendant agrees is owed?
Yes, Your Honor, if
I think he may be frozen. Everyone just froze. Mr. Levy, I'm sorry to ask a question. It looks like everyone froze on my end.
Oh, can you hear me, Your Honor?
Now it's my Zoom that's behaving badly. Hello again. It tells me that my internet connection is being unstable.
Uh-oh.
All right, Mr. Levy, I had asked a question. Ms. Ramos says that the defendant had paid her $41,39.50 and that she has an outstanding balance of commissions owed of $11,062. So my question, just real quick, Mr. Levy, was, is there any portion of outstanding commissions that the defendant agrees is owed to the plaintiff?
Yes, Your Honor, and that is in exhibit number 4, defendant's exhibit number 4. It shows
how much is that?
That is $1,878.89.
Okay, so that's a substantial difference. All right, so how about $400 for coaching? Does defendant agree they would refund that or that they owe that to the plaintiff?
No, Your Honor.
Okay. How about any of the refund she's seeking from the classes she enrolled in? Any portion of that the defendant says they would refund or acknowledges should be returned?
No, Your Honor. And we provided her withdrawal from the class, and prior to that, she received all materials.
We'll go through it. I'm just straight up front. If there's any part of that that's conceded by the defendant, then I can go ahead and just sort of set that one aside and we can get into the rest of it. So
Absolutely.
1878 is acknowledged between the parties. There, that part is there. It's the remainder of the commissions that are at dispute and then all the other things. All right.
Yes.
All right. All right. So now, Ms. Ramos, you signed up for the class and you said that you watched a video in the class. The video gave you information about what you were paying for in the package. Did there come a point where you asked for a refund for the package that you had paid for classes?
Your Honor, the refund for the package is connected to legal notices that Ms. Cutler sent me. So there's a bit of a chronology where Ms. Tate, we had a disagreement about the recordings, which will come into, I believe, in their counterclaims. I was terminated from my closure role mid-sales call and mid-month in October. And I received 3 legal notices, 2 cease and desist from Ms. Tate personally and 1 directly to my home. And then 1 from Treaty Oak Law Group, Mr. Levy. And part of those cease and desists, I was demanded to cease communications with clients. And there was a bit of a murky area there because those clients were also part of the community that I paid to be a part of and to communicate with. And so that's where the refund comes in because I, part of that package was being able to communicate. And so if I can't communicate with what I paid for to be able to communicate, then it puts me in a bit of a legal bind.
Mr. Levy, are there any written terms and conditions for any of this stuff?
No, Your Honor. No, Your Honor.
No, I heard you. I'm just sort of taking that in. So we have $11,000 in commissions that are owed, but no one bothered to put any terms and conditions in writing? She's selling a
No,
package
Your
for a
Honor.
class and there's nothing in writing from the law, from LLC that says this is what we're going to provide when people pay us?
No, Your Honor. And not at the time.
Well, that's what matters, right? Coming up with postmortem isn't going to do them any good. It's at the time they entered into the agreement. So there's a whole lot of questions of fact because literally no one bothered to put anything down. All right, so we got no written agreements at all. Ms. Ramos, you said that in October, defendant said you couldn't do the work anymore since your cease and desist letter told you weren't allowed to contact people or clients, but some of those clients were part of the referral network or the online community network that you were paying to be a part of, and so that's why you're wanting a refund because you couldn't do it anymore? Okay.
Correct.
Now let me ask you this. So you paid for a package and you did get to access it, and then in October they stopped it. So why would you want the entire money back and not some pro rata refund?
Sure. So based on Texas law that was established, the Texas Prevention Doctrine, a party who prevents or makes impossible, sorry, I'm the wrong one, excuse me. Not a lawyer. But Ennis versus Interstate, which is when a party commits a material breach that goes to the entire essence of the contract, the non-breaching party has the right to rescind the contract and seek restitution of any money paid. And so this being able to communicate with clients was an essential element. And it was actually a really meaningful element that I still had access, that I was still supposed to have access to until April 2026. And when that was taken away, and because she initially took me off the platform, and then I wasn't able to communicate with the clients. I let her know I was back in, but then she sent me these notices. Thank you.
What's the reason the defendant told you to stop doing work in October?
So we had a disagreement about recording. So my sales calls were recorded for my own use. And I offered Ms. Tate to be able to review them if she wanted for some of them. And Ms. Tate on October 15th asked me for the actual downloads, like the actual files. And I didn't feel comfortable with that as the owner of the recordings and because of the content of the recordings. And because I did not give those recordings and I said that I wouldn't, Ms. Tate terminated me the very next day.
So you were doing work on her behalf and you recorded those calls, but you refused to give them to her?
Correct.
All right, and as a result, she terminated you.
Correct.
All right. All right. And then you said you received cease and desist letters from Mr. Levy's law firm or others with their firm? Is that the point of
Correct.
you hired of the lawyer in Florida?
Correct.
Okay. All right. All right. So let's take a look at the breakdown for the commissions, the $11,000. Now, Ms. Ramos, I think you said you submitted that to the court in advance.
Yes. It will be Exhibit A3, Camila Closer Performance. This is also the majority of this, like the month-to-month breakdown was a file on Google Sheets that Ms. Tate always had access to. So she had a,
Ms. Ramos,
yes, sorry.
let me ask you a few questions. I need to establish
you.
this is useful for court. So I'm going to
course.
share my screen, and this is a 14-page spreadsheet. I'm just going to quickly
Correct.
see that most of it is all spreadsheet with some words at the end. Ms. Ramos, was this spreadsheet something that when did this spreadsheet get created?
At the start of my independent contractor role so that I can keep track of everything.
So this was originally opened in September of 2025.
Maybe late August, I set it up, but sure. Yeah, I began filling it out with my
then.
calls. Yeah.
It was done in purposes of the job and not just for coming to court.
Correct. And
Now,
and
Ms.
it was a
Ramos?
live document. Yes.
Ms. Ramos, would you, or how often do you update the spreadsheet?
Every day. I mean, every day I had a call and I would close it or not.
And was the idea of keeping a spreadsheet something that you decided to do, or were you instructed to do that by the defendant?
I decided to do it, Your Honor.
And then on this sheet, when I'm looking at it, I see up the top, I see some dates, I see calls, close rate, sales, average, commission, paid to date, all of these things.
Mhm.
And then down here, how would you submit to the defendant proof that you had done work and needed to be paid?
Sure. So two things. One, this was a live Google sheet that the defendant was shared with and would update her in real time as I would update it. And then
So
at
the
the end of the
defendant also had access to use this sheet?
to view it, not editor access.
Okay, go ahead. So she could see it.
And then also at the end of every call, when I would close a client, it was my responsibility to notify Ms. Cutler, the defendant, excuse me, and let them know the person, the amount of the total amount, and the email address so Ms. Cutler could send the client contract to the person that I had closed. And so that was part of our procedures. So I have a record of every text message, of course, that I sent with every closing, the name, the amounts, and the email addresses.
All right. Now you did work in September and you submitted that and asked for payment. And she did pay you at some point $4,139.50. And then in October, you're doing work. She sends you the cease and desist, or she tells you to stop because you weren't going to let her hear the videos that or the audio recordings. What is these numbers here going forward, November, December? Explain these for me.
So where it says collected amounts, that's the amount that was. So the month of the transaction was, okay, sorry. The transaction month was what closed that day,
Or in October.
what was paid. Correct. And then each month also shows what the amounts were. So it's a little easier if you go to the next sheet. Would that be okay? So you see how this is each client and then what their total package was, and then what I collected on the day of closing, and then when their second and third payments would be, which were monthly. So the first sheet outlines those totals that would be, so I collected a certain amount in October, but some of that wouldn't be collected until November, December, January. So my first sheet is a summary of that. And then
You signed people up to pay packages, and whenever they paid, you got a share of that.
correct.
It's very sort of like that shape. People below you, you sign up, you get a share, and then you share that with the woman above you, and then she cuts you a check. That's how it feels. That's how it's sounding, right? Ms. Tate, you, people below you, they pay, you give that money to Ms. Tate, Ms. Tate gives you a little share of it. It's like any hierarchy. All right. So now in October, you've collected $3,000. You say down here, there's a different collected amount. There's this collection number. There's your 17% you create. And then this number going forward, because after October, you no longer work for. Why is this still here?
Well, those are amounts that I closed in October or September. And I realize now that there's an error here. There's missing a column for September. So pardon, but the rest of the data on the next sheets are accurate. So again, let's say somebody bought a package for $4,800, as you can see here. And can you go back to that sheet, please, Your Honor? So somebody would buy a package. The total value of that package would be $4,800.
Right,
On that day, I collected $1,000 deposit.
You should get 17% of that.
Correct. And then the next month, when the rest of the payment plan would go through, I should get 17% of that, and so on.
And it's precisely this reason why we object to this, Your Honor. This is Mrs. Ramos's opinions. That's not what it was actually collected. It's what she thinks would be collected.
Yeah, I get that. How would she know? She doesn't have the accounting.
Right.
This is a projection. And again, that's why my very first question, Ms. Ramos, was what happens if these people don't pay? What if everyone you signed up in October right here says, I also don't like this course I've signed up for, and they turn off their credit card and never pay? Your expected payment is not valid. She's got to actually get the money before you got to get paid.
Sure. Ms. Tate had a contract with those clients, and I understand that.
I get that,
I
right?
made the assumption, yeah.
If they don't pay on the contract, it's irrelevant to whether you get paid. Well, that's not true. She could sue them all day long. If they never pay, you're never getting paid either.
I have a question about that, Your Honor, or a curiosity, because it seems to me that, which was the case law that I was going to bring up, which is when a party who prevents or makes impossible the occurrence of a condition, the condition being paid on collecting.
Ms. Ramos, listen to the logic I'm using. Ms. Ramos,
Yes.
if you sign up me to pay for a course and I stop paying and Ms. Tate never gets my money, Ms. Tate never has to pay you for you finding me because you didn't find the client. And there's nothing about her making it impossible. If I don't want to pay, I'm not paying. And as a result, you don't get paid because your agreement with Ms. Tate was wholly contingent upon me paying.
I understand, Your Honor. The point that I would like to clarify here is I believe that what Mr. Levy is bringing up and part of what Ms. Tate is reconciling is not that clients didn't pay or that payments didn't go through. Ms. Tate authorized refunds, which went against her policy. And so they are discounting those refunds that Ms. Tate authorized, so that is why I bring up that she made it impossible to collect.
Ms. Ramos, as a business, I don't see why she couldn't offer a refund to someone. You're literally suing her for a refund.
Well, I didn't, as a client, I didn't have an agreement, a signed agreement with no refunds. Part of our agreement as a closer was that she would send this client contract that included the terms of no refund and payments to collect to the other clients.
Do you have that in writing?
Yes.
Let me see that. What exhibit is it that shows me that she's not allowed to offer refunds on people you fine for?
Well, I have her client contract that of course I was privy to.
Ms. Ramos, is that a contract with you or is that a contract with a third party?
Well, I have a video recording of Miss Tate saying that it's her response that she was going to send these contracts to the clients.
Sure, but that's not your agreement with her.
Yes, so we, in our, before I ever closed the sale, before I ever began on videos, Miss Tate and I got on video, on calls, on video Zoom calls. And where the role was continued to be explained before I formally accepted. And part of that was that she explained to me that I would get on these calls, close them, send her the information, and she would be responsible for sending this contract to the clients that included a no refund and a payment, a responsibility to pay, excuse me. So I have a video of Ms. Tate stating that's what she would do prior to any call that I ever completed. So I understand that there wasn't a contract, like a formal contract, but there's sufficient recorded material, which I believe should be enough legally, but obviously I defer to you, Your Honor.
Mr. Levy, what's the counterclaim about?
Your Honor, and this is what Ms. Tate will explain, Ms. Cutler will explain more information about, but the reason why we had to issue refunds is because Ms. Ramos contacted clients and badmouthed Ms. Cutler and Unfuckwithable, and so those clients wanted their money back.
So you're alleging that it's the plaintiff's fault that the refunds occurred?
Yes, Your Honor.
Do you have any proof of that?
Yes, Your Honor.
What type of proof do you have?
We have the messages from the clients, and that is Exhibit 8. And I think that might be both of them. Let me check.
Client refunded withdrawal communications.
Yes.
All right,
And
I'll
Ms.
take a
Cutler
look.
can
Let me share my
explain all
screen.
of them. Sorry, Your Honor.
Let me take a look here. I'm gonna do a little bit of, I'm gonna cover up some of the names for the people that are not actually a part of this. I'm not trying to have them.
Sure.
I
And Your
recognize-
Honor, Exhibit 4 shows what was actually collected.
Okay, hold on, let's stick to this one, right? So part of the counterclaim is that the refunds occurred because plaintiff's actions resulted in those. So this is the item that was provided as Exhibit 8 by the defendant in advance. And I can see that these are screenshots, but look to be, I'm not sure. Mr. Levy, what is this?
Your Honor, I believe it is Instagram, but Ms. Cutler can clarify that.
It is School. So it's the platform we use for client communications.
Hello, I wanted to contact you, let you know I appreciate what you've put into your program, but it turns out it's not exactly what I was looking for. I want to end my time and being taken out. Wishing you the best. Okay. I'm reaching out regarding my enrollment. I won't be able to participate. I spoke with Camilla as my point, didn't get any kind of paperwork, found myself in this kind of feud, and the recipient of many, many text calls and emails from her that have made me very uncomfortable. I wasn't even told the duration of the program or anything. I'm requesting a refund for the $1,000 I put down. I'm a mama too. I make 50 a year. I want to make. So part of our complaint is that y'all took money from her without her knowing it was going to happen, or that she didn't realize that.
Your Honor, I want to.
Ms. Ramos?
Oh, I'm sorry.
I'm reading.
I'm sorry.
Right? I'm reading. I was really upset to have money debited from my bank account on the first when I had no idea that would happen. So this is a woman who's upset that she's had her money taken from her without expectation. She wasn't prepared for that. I don't know. She spoke to someone as a point person, got no paperwork. That sounds accurate since no one here does any paperwork. In the middle of some kind of feud between you both, right? So she's referring to Miss Ramos here, which sounds accurate. And this is, I don't know when this is because there's no date on any of these. Sometime in the middle of the morning, 1 a.m. All right. From one month to another, I'm asking for help. All right, so you got one person who complained about Camilla. The other two just said, I don't want to be it. That's not very exciting. All right, what else is the counterclaim? So you said that the defendant refunded the money because plaintiff badmouthed defendant. That's not a counterclaim. That's why you're not giving her back her money. What's the counterclaim for?
Tortious interference with the contract, and that these individuals, and Exhibit 7 also is another example of a client who canceled after receiving communications from Ms.
And
Rama.
am I correct that school is spelled SKOOL?
Yes, Your Honor.
Okay.
And so part of the counterclaim is that Ms. Cutler had to spend time retaining clients, and the other part of the counterclaim is that she lost clients. Both of these were the result of Ms. Ramos's bad mouthing, for lack of a better word. And
How are you valuing that?
we're valuing that as what was the cost of the program on ones who took a refund. And the other ones are the ones who were retained. The value is the hours that Ms. Cutler spent giving them free sessions to retain them.
What is the session about? My curiosity is getting the better of me. What is exactly this course about? What are we learning at the school program?
Maybe let Ms. Cutler answer.
Yeah, I can answer that. We teach women how to scale their business on social media. So we use Instagram as a lead generation. We teach holistic practitioners, service providers, coaches, and we build out full funnels for them all the way from Instagram lead generation to sales.
Okay. All right, Mr. Levy, you said Exhibit 7 was more proof that Ms. that Ms. Ramos had interfered with contracts.
Yes, this is just another client that was canceled as a result of Ms. Ramos reaching out to her.
I mean, I see one of them where she's like, cool, I got that email. I'll send it to you. Grateful to be here. She didn't cancel. She's ecstatic.
Ms. Cutler,
I mean, I'm reading this one right here. This might sound a little intense, but please read through it.
and if
this
you
is
look
the
at
email
exhibit,
that Ms. Ramos sent her. Okay.
if you look at exhibit number 4, that lists all of the sales that Ms. Ramos had, and it breaks down the 2 people that completely canceled, which is Ms. Cole and Ms. Shanley. And it
Sorry,
lists
Mr. Levy, I was still reading through Exhibit 7.
Oh, apologies, Your Honor.
What other, now you want to turn my attention, what's the other exhibit?
Exhibit number 4.
7, 8, 9, 10, 1, 2, 3. Let me look. I don't find 4. I see 1, 3, 5. It's missing. Maybe it's out of order. No, here it is. Spreadsheet. Defendant's exhibit 4. Y'all, they all came in. We were kind of pushing everything in together, so it's just a little bit. Okay. Let me expand and share my screen. I see a lot of names on here. Okay, but nothing to identify. Okay. All right, now, Mr. Levy, is this something that was prepared in advance of coming to court?
This was Miss Cutler gave it to me. I believe it's a business record, but she could speak to that. I don't want to mislead the court.
Ms. Cutler, I'm sorry, Ms. Tate,
Yes.
was this spreadsheet something that you had already had prepared, or did you create it to give to your lawyer to get ready for the case?
We have a spreadsheet of all paid commissions, and I just took the ones that Camilla was responsible for in the 6 weeks she was with us and put it on here.
Yeah, so this is an item prepared for your lawyer for court. Okay. So this is not the actual record. This is the record put into some other form. But all right, let's take a look. So commission owed versus paid and retention time net position through November of 2025. So this is 1 month after you told Ms. Ramos to stop working. Yeah, see right here, I mean, clearly it's prepared for court. She stuck it all up here and got an hourly fee attached to it. All right, so this is definitely an exhibit for court. No worries, that doesn't mean I can't look at it. Just say that it doesn't have the same historical record that it would otherwise give me. All right, but we got people here, cash collected, commission rate of 17%. Why is this one 15%?
Can I answer that?
Yeah, no, that's what I'm asking.
15% was 17% was when she hit an accelerator. That's the call she referenced. We referenced in the end of September. 15% is what her commission went back to if she hadn't closed 70K in sales that month. So she did in October, so it went back to 15%.
Okay. So she was owed $6,000. Now here's my question. This is cash collected through November 1st, but it says that you paid her in October. So I'm confused about that.
Can I also answer that, Brian?
You know, you have to answer
Okay.
it. That's why I'm
Okay.
asking.
I just don't know who you're asking. So we paid her October 2nd to pay her for September. The rest of this would have been through the duration of October, even to the end of the month when after I let her go mid-October.
So she was owed $6,000 in October.
Correct. Like total. That's total.
Yeah,
Of what
see,
she's
that's why that's why I'm confused. Your calculation says that at the end of October, because of money collected through November 1st, you would have cut her a check for $6,000. But why would you cut her a check for $4,000 October 1st when you don't know that you've received the money?
So I think maybe there's confusion around like the payment plan. So payment plans come in. So we had people pay a payment plan in September. She gets paid 17% on cash collected.
Right. So
So
that's
I
what I
paid
assume
her.
this $4,000 is, that she was getting paid her 70% of all the money collected.
Correct.
Then
And
don't you
so
owe her another $6,000 at the end of October for money that came in on those accounts?
no, so that's total. She would have been owed an additional, whatever the difference is, 2,000 something on the cash collected in October.
Did you pay her any portion of this 2471?
No, and
Why
we
not?
have well, I mean, do we go into the counterclaim at this point? Can I just explain from my
Yeah,
perspective?
that's kind of what we're doing here. Now here's my question, Mr. Levy. I'll come back to you. So when I asked you how much defendant agrees they owed her, y'all told me 1878, but the number right here is 2471. Where's that $600 difference going?
So this is what Camila owes, what Miss Ramos owes Miss Cutler, or the company. When you
What does she
factor
owe
in the
y'all? Oh, this-
4,300.
Okay, I see. All right, and then time saving her clients. Y'all are killing me here, y'all. Just so I'm clear, two women who agreed to help each other promote their businesses through social media and scale up have no signed contract whatsoever. Just so I'm clear, a company that purports to sell a package to help women scale their business did not have a written agreement with someone they hired to do sales for them. Mr. Levy, is that an accurate statement?
Yes, Your Honor.
Okay. And now those two women have come to the court for confusion over an illicit problem that they could have solved through better accounting and, I don't know, some of those lessons they were trying to teach to each other.
Yes, Your Honor.
And now they are both creating issues, including time and effort and hassle they've both spent, when all of this could have been resolved if they had made a clear, written, independent contractor agreement in the get-go.
Yes, Your Honor.
All right. And now they're arguing over how much is actually still paid. Do you have any proof for me of what Ms. Tate's company brought in from those commissions for the clients that Ms. Ramos found? Is that the
Ms.
spreadsheet I just saw?
Pardon me, Your Honor?
Is that the spreadsheet I saw, the actual money collected from those cases?
Yes, Your Honor.
And per that calculation, defendant says 1878 is still owed to her, but then y'all are seeking to get money from her as a counterclaim for having to go back and talk to all those clients that she sent the email to.
Yes, Your Honor.
Ms. Ramos, I saw some messages in the school platform indicating you had sent an email to some of those parties. Is that accurate?
Your Honor, I had sent a text message, and I'm happy to explain. So
You don't have to
No.
explain it. I'm just asking
Well,
if you
there-
sent it.
yes, Your Honor.
Yes. Okay, so you sent it. All right. So you sent a message to some of the other people and said, I'm disappointed and unhappy with the situation going on. And as a result, they reached out to Ms. Tate and said, what's happening? I've seen those messages, Ms. Ramos. That's a fact, right? I just read them from those people in school saying, yeah, I got this long message. Let me show you what Camilla sent me. Sounds like y'all have a lot of drama. That's true. Your messaging those people caused them to call Ms. Tate and say, why am I hearing from Ms. Ramos like this?
Your Honor, I would like to bring up that regarding the defendant's Exhibit 8 with Ms. Cole, I have a record that I also submitted of my text message with Ms. Cole. The reason I reached out to these clients and what the message actually said, which was largely omitted in that screenshot, was these women paid thousands of dollars to be in this program. There were certain gaps in this program that I made Ms. Tate aware of and that I created solutions for. Ms. Tate and I were in constant communications on improvements to her program. We were talking about me being a coach, I was going to help those women when I closed them with these gaps. I thought that I could help them. When I was terminated and I could no longer do that, I sent this message offering to share it with them, information that I thought was awesome, that could help them succeed in Ms.
Ms.
Tate's
Ramos,
program.
The things
Yes.
you pointed out to them were things that you found to be flaws in Ms. Tate's program.
Correct. And these are flaws that I brought
That
up
would
to Ms.
be,
Tate
Ramos,
and that Ms. Tate
Ramos,
agreed were flaws.
that would be considered intentional interference with the business contract.
Your Honor, I
Which
had
would
no
be a
non.
sufficient reason, Ms. Ramos. You're supposed to know these things. As an adult entering into business, the law says you're supposed to learn them. I know that's frustrating. I'm trying to help you out here.
Well,
If you
hold on.
sent an email to clients that Ms. Tate introduced you to, bad-mouthing Ms. Tate's business practice, that would be a reason for Ms. Tate to fire you, as she did in October.
Your Honor, these messages were sent post-termination. Again, I had access, correct, and I had access to these clients because they were also my colleagues in the program. And I would also add that nothing that I said was defamatory, and everything that I said I had previously brought up to Ms. Tate, and she agreed.
Okay,
These
let me ask
were,
you this, Ms.
these
Ramos.
were,
You,
okay.
you brought up a timing question. Mr. Levy, did she send that message before or after Ms. Tate let her go?
I don't know the facts, Your Honor. I would
Ms.
defer to
Tate?
Ms. Cutler.
Yeah, she sent the message after I let her go.
So then that's not a reason to let her go. Why'd you let her go?
When I requested that she send me sales calls for review, which is how I review and quality assurance on sales, she refused to send over the sales calls. And after that, I let her go.
And do you have anything in writing that requires them to send you those sales calls?
No, and everything you've said, I completely agree with. Like, I'm completely changed the way I do business from this situation, and I was an idiot at the time.
I won't disagree that I feel disappointed in everyone's actions here. As women, we're all strong with it, ladies. But you're all really disappointed that none of you bothered to put anything in writing, and you're spending thousands of dollars to try to be business people, but you're going about it, frankly, irresponsibly.
Agreed and heard.
And that you're trying to coach and school other women and get them to do this is frustrating and disappointing as an individual. Legally, right, I got to figure out your situation because you've got a handshake agreement for a promise to be paid, and I don't know when to be paid. I mean, honest, the very first thing I wrote down when you told me how you're getting paid, Ms. Ramos, was, don't we have a statute of frauds problem? And Mr. Levy is shaking his head immediately. There's a huge problem with this. Now, luckily it didn't go on for more than a year because within the first month, Ms. Cutler said, stop doing this. And Ms. Cutler, there's nothing that says she can't just fire you at will. You're an independent contractor, so she doesn't have to have a cause. In fact, even if you had been an employer-employee relationship in Texas, Texas is an at-will state, so you can be fired for any reason, except a discriminatory purpose, right? But I don't like you cheered for at the World Cup. I could fire you for that. That might be nice, but it's not illegal in Texas. So the relationship between the plaintiff and the defendant was just that, arm's length. You're an independent contractor. You could terminate it at any point. The question is, if you terminated her without cause, and I would say that if the reason you terminated her was you didn't see her sales calls, but she's not required to give them to you, I don't know that that's for cause. I think it's just, okay, I don't want to do business with you anymore. That's not how I'd like my independent contractor to work. That's reasonable, but she's still got to get paid for the work that she had done. So she still needs to be paid. And there's no dispute whatsoever that she's owed at least $1,878. So we got that down. And then Ms. Tate, or Ms. Cutler, you say after that, these parties still owed money. Did they finish paying out their accounts?
No, however many of them I wrote on that sheet either stopped paying. However, it was that two people who wanted the full refunds, I gave it. One, Nadine, who is in Camilla's exhibit, stopped paying due to sickness. admittedly unrelated to Camilla. So we, however many there, we show you when their payment plans stop. The agreement that we had either verbally made or in WhatsApp message, not in contract, was cash collected. I did not collect the cash that she is saying I collected.
So Nadine paid 1,000 in September, 633 in October, 633 in November. And never paid
Your
anything
Honor.
further. So the commission you calculate is 385. So altogether you calculate commissions owed to the to the plaintiff of 9,223, and then you less what you paid her. And so this second page says there's a $5,000 commission owed. I'll share my screen because this is y'all's exhibit. All right, so here's the pages from the defendant, exhibit 4. Here's the first page, but this is the second page, which is more complete. And this one is the exact same names. They're just not in the same order. But like, for example, you mentioned a person named Nadine. So here she is. She's down here this time. In September, she got signed up by the plaintiff, paid $1,000. In October, she made a payment on it. Miss Cutler lets the plaintiff go. Plaintiff sends an email. Regardless, Miss Nadine, she pays another $633, then she stops. All of these have payments going through January, or at least some of them. And there's a total amount collected. Here's a refund that's given for one of the cases. But over here, commission owed, 9,233. And then here, what is she owed versus what she claims, less commission owed to her for comparison. So here you're getting a much different number. You say altogether $9,000 is owed to her. She's actually been paid $41.39. So here the number is 5,000. So is that what she's owed? Because that definitely begs the question.
This was calculated, it looks like, based on Ms. Ramos's numbers. For
No,
comparison.
Ms. Ramos says 11,000. See, for comparison, she claims 11,000. This is y'all's sheet.
Oh, I think the distinction, Your Honor, is that some of these commissions were collected after she no longer worked there.
Yeah, that doesn't mean she's not entitled to get paid.
Well, our
Nothing in
position,
their contract says she's not still entitled to be paid. The fact that she doesn't work there anymore, she's still closed on the deal at the time. They don't have anything in writing that says you have to still be an independent contractor, keep getting paid. Any reasonable person would say you owe me the money. I'm the one who got you that contract in September, and you got paid on all the way through January. Where's my 17%? All right, so here's a new number, 5,093.
Your Honor.
Who is that?
It's Ms. Ramos. I just want to point out in this exhibit, it goes through January of 2026. Whereas there are still payments that Ms. Tate received in February, March, April, May, and actually until August. There would have been as far as the prospective payments expected.
Ms. Cutler, have you received additional payments on any of these accounts after January of 2026?
So most of our payment plans are 4-month payment plans. One of them was 6 months, but I upsold her into a different program. So it's getting kind of logistical, but there's one Launchpad at 4,800 and one is Breakthrough at 1222. The only one who paid additional after that would have been Michelle, where's her name? Michelle McKay, the first one. So Camilla is owed the commission of the thing that she sold. And the thing that she sold was the 4-month payment plan at 4,800.
So I'll ask it again, Ms. Cutler. Have you received any money beyond January of 2026 for clients that Ms. Ramos secured in September and October?
Yes, for Michelle McKay.
And how much money have you received since January of 26?
I'd have to double check that.
Go ahead and pull it up.
Okay.
and just to clarify, Your Honor, our position is not that she's not owed the forward-looking money because she was terminated. It's because she actively jeopardized the business. She forewent.
That's the counterclaim. That's the counterclaim that she then interfered. So y'all owe her the money. What you're saying is that she owes us money as a result. It could wash.
Well, Our position is that because she actively went against the business, that she shouldn't be entitled to those commission payments.
And I'd say that's self-helping, Mr. Levy, right?
I
Otherwise,
just
you
wanted
cater
to, I
in
just
the
wanted to
suitor.
clarify our
got it.
position.
I got it. Your client self-helped. Rather than pay her and then sue her for refunding the hassle she spent, she said, I'm just not going to give you the money because I've spent a lot of hassle trying to recover the clients that you badmouthed me to. That's a self-help provision. It's not the legal way we go about it, but that's essentially what the plaintiff, what the counter plaintiff is trying to do or did do. All right. And I'm just saying though, that she owes her something. So let's figure out that number and then we'll determine if she's entitled to anything because of Ms. Ramos's interference. But let's figure out what Ms. Ramos is owed because that's the original claim. So right now we've got her at $5,093 plus whatever 17% comes from what was received from that account in February. Or March and April, any amount you still received from these accounts after the spreadsheet ends, Ms. Ramos would be entitled to a commission on those.
But just to be clear, she doesn't receive a commission on something when the client's working with me and continues to work with me.
Ms. Tate, I don't just, well, that's what my question was. You, in this spreadsheet, you have those numbers in September, the things that Ms. Ramos secured. So she's only entitled to 17% on those as they're paid. If after you were going and say, you know, January, one of those people signed up for a new package, Ramos doesn't get 17% of the new package because she didn't secure that. But if the person is still paying on the original package, Ms. Ramos gets 17% of that. So that's what I'm asking is, have you received any payments on the original packages that are not reflected in this spreadsheet?
No.
So that's everything.
Yes.
Now,
Not everything.
You haven't gotten any money after January on these accounts that Ms. Ramos secured.
Not to my knowledge. I did the calculations and I believe that's correct.
Do you believe it or can you swear to it?
I believe it.
All right. Now, that's Ms. Ramos's claim in chief, right? That is her commissions. She sought 11,000. Y'all have acknowledged a good portion of that, 5,093. And that is through January. Ms. Ramos, how much of your claim is for money that would have occurred after January 2026?
So I can do the exact math, but I want to point out the clients that perhaps Ms. Tate can look in her records for. I've got Holmes Nadar, that's payments collecting through April 2026, as well as Michaela Rager, Katie Magelstein, Emily Baldwin, Lindsay Thompson. These are all payment plans that were established that.
Ms. Ramos,
yes,
those names are all on the spreadsheet. Ms. Tate just swore in court that they didn't pay anything after January. I know what you're saying is you believe they did. I don't have any proof one way or the other. She just swore under oath that they didn't give her any money. If you find out later that's not true, she will have committed perjury. But unless you have evidence or proof, like you've got a hold of one of those clients and they said, yeah, I absolutely sent her money last February. What you talking about? That is your position. But her sworn statement says that this is an accurate reflection. She has acknowledged her statement today and her sworn evidence that she owes you $5,093.90. That's not in dispute anymore. You are going to win that amount of money. Now the question is, do you owe her any money for sending that email after she terminated you?
And just to be clear,
and we are not done with your other parts, right? You also wanted back a refund of your class and the $400 for the coaching and $1,500.
Right. And I couldn't have, well, okay, thank you. Yes, I understand, Your Honor.
Now, you were supposed to be paid $400 for coaching, correct? Ms. Ramos?
I paid, $400 for coaching, correct. Thank you.
Okay, and did you perform the coaching?
The agreement was $1,600 a month. I performed one Thursday, and so out of fairness, I'm asking for my prorated share instead of the full month.
All right. Ms. Cutler, is that correct? Did Ms. Ramos perform one time as a coach for your service?
She did one coaching call.
Okay. Was there any understanding of how many coaching calls for $1,600?
4, so there's 4 per month.
Okay. Oh, 4 per month?
Correct. So every week.
Okay. All right.
And also I'd like to amend my earlier answer because as you were talking, I just calculated Michelle McKay because I wanted to see the difference. The difference is 1614 from what she sold her in. So she sold her into something at hold on, sorry, 1 second. 7,650, and we collected 1614 more than what is stated on that document. And the reason why is because she upsold into a different thing.
Who
So-
upsold? Ms. Ramos upsold her?
I did.
So then Ms. Cutler, my question is the additional 1614 paid by Ms. McKay money that is owed to, that would Ms. Ramos get a 70% commission on that? Or is that money she paid as a result of your upsell?
The upsell was later in October. That would have been a result of Camilla's actions. She would have gotten an additional 17% on 1614.30.
Fantastic. That means you get an extra $274.38. All right, thank you. All right, we got a coaching call. And then Ms. Ramos, you were seeking a refund of the course you signed up for, and that was $44.10. And I can understand that there's stuff to the package. Now, you signed up for the course a few months prior, though. I think, was that in April? Do I have that in April? In the
April
spring.
16th, Your Honor.
Okay. And so April through May, May through June, June through July, July through August. Were you participating in the program?
April through, I believe, June. I had a really hard personal situation in June, a pretty violent experience, and I asked Ms. Tate if I can pause on the program so I can focus on that.
And did she agree?
Yes.
Ms. Cutler, is that accurate?
Sounds correct.
Okay. Ms. Ramos, did you then ask to start the program up after June?
Correct.
Okay, and when did you begin the program?
I commenced, I believe, the third week of August again.
How long was the program supposed to last?
Access to the community and the platform was for a year. Well, I mean, it's assumed that I could talk to the women that I met there indefinitely, I would say.
I guess here's what I kind of need. I need to know what you paid for so that I can determine what you got out of it and what is remaining. So when you spent $44.10, did you have an understanding of what you were getting, like 5 coaching centers, 24-hour access for 6 months to a site? Like, what did you pay for?
Yes, it was 24-hour access to the site for a year, which included, that site also includes the community and also access to 16 group calls per month. And that access to the group calls was only for 4 months.
So you got 16 group calls each month for 4 months?
Correct.
Okay, so you got 1 year, 24-hour access to the platform. Each month for 4 months, you're going to have 16 group calls. What else could you do?
I believe that's it.
Okay. All right. Now you signed up in April, but almost immediately you had something interfere in life, which can happen. And so you asked Ms. Cutler if you could pause the program. When you asked to pause the program, were you pausing payment, or were you wanting to extend your time and therefore sort of delay opening your membership?
The time. I had already paid in full by that point.
All right. Did you already have access to the online portal in April?
Yes.
Did that?
I mean, not prior to April, but in April,
when you paid,
the
you
access
got
began.
access to it. Okay. And then when you
Yes.
asked to pause your membership, were you still able to access the program through April through June?
Ms. Tate said that she would continue to give me access through that time.
And how about the group calls? Did you participate in any of the group calls between April and June?
No.
How about after the pause? When you came back, now we're in July. Did you participate in any of the group calls then?
August, you mean, Your Honor? I recommenced in August.
In August. Okay. How about beginning in August? Did you participate in any of the group calls?
Just for a little bit, and then my role as a closer began, and I was also asked to be part of the calls as a closer, so that we get into sort of really muddy territory there.
All right. But you were not, you were had access to it and could utilize the program that you had paid for at that stage. All right, so that's August. In September, same thing. You could access it. You could use the group calls. You could do the platform.
Correct, Your Honor.
And I understand that you might be having sort of two hats at some of the meetings, which
Sure.
gets a little bit
Yeah.
strange. I know. I do the same thing. Sometimes I'm both a member and a board person. I'm like, which one am I voting for, right? So I understand. All right. So in September, you're still doing everything like normal. How about in October?
In October, my access to the platform was removed on October 16th when I was mid-sales call. But as a client, it was removed that day.
And so it's sort of two things. You were removed from access to the portal because she stopped you being an independent contractor, but you should have had access as a customer, and that was taken away from you as well.
Right, Your Honor.
Were you given any information about whether you could access the group calls and continue on going for the next year?
No, Your Honor, we didn't discuss that.
Okay, so from November through April, you did not receive the benefit of the thing that you paid for.
Correct. And I also asked, which was part of the defendant's exhibit and her screenshots conversations with me, but I did ask if we could align on when the end date would be, because I recognized that it was kind of all funny, but we never got to that.
Okay. All right.
Your Honor, our exhibit 5 shows that in October 16th that Miss Ramos actually, or maybe that's not the right exhibit, I apologize. It is. It is, no, that's not the right exhibit.
Mr. Levy, did Ms. Ramos continue to access the platform after November of 2025?
Miss Cutler would be able to answer that.
So after October of 2025, after we had a call, I took her off the school platform, and then she said, hey, I'd like to continue on the school platform because I paid for it for a year. And I said, that's totally understandable. Let me go ahead and add you back on. That same day I added her back on, and she churned herself the same night. And that's been confirmed by school's back end. Their tech have confirmed that.
Okay, so you say that you put her back into the portal as a student.
Correct.
And what did she do?
She removed herself that same day.
Ms. Ramos, is that accurate?
Your Honor, I notified Ali of of being taken out as a client. She invited me back in. I initially went in, but I didn't leave the program until she sent me a cease and desist to not communicate with the clients. I believe that was 2 days later on October 18th. Perhaps the records that school has is from her original churning, I believe the term is, of taking me out on the 16th.
Okay, so Ms. Ramos, she took you out of the portal. You said it was mid-call. Ms. Cutler says that you then contacted her and said, hey, I still want to use the portal as a student. I paid for it. And that she agreed and gave you access.
Invited me back, correct.
Okay, so that's true.
Correct.
Since you were invited back, but you're saying that after you were invited back, you then got the cease and desist letter from the lawyer.
Correct.
Okay.
From Ms. Tate, it was 3 letters. Sorry. Sure.
Did you, and this is where I don't know, did the lawyer you called or used, did they explain to you any of the distinctions between you as an independent contractor and you as a customer and where your rights and responsibilities lay in each of those?
Correct. And they advised me just to be safe to cease all communication. And so that's what I did.
Right, that's community, but how about using the thing you paid for, the portal? Or the group calls?
No, Your Honor, at this point,
Okay.
that wasn't, there was so much, not to bring in personal
All
things,
right.
but I was
I
in a
can
very,
understand it.
I
get
just
it.
needed to get paid. Yes.
There's a confusion and a hassle in that one. Or I can see, I can understand how the parties would be uncertain of what to do in those situations. All right. So let's go back. That's the That's the refund, coaching, commissions, and then you hired a lawyer. That was the lawyer there in Florida who gave you some advice. I can understand that. And I will just say, both Mr. Levy's advice that I could see he's given his client and the advice that you got from your lawyer, well, those are all pretty standard things. All right. All right. Got the platform. Put back on, chose not to use it. One there, one on that one. We'll see. All right. I think that resolves everything I've got on the plaintiff side. How about Mr. Levy? So now the counterclaim. The counterclaim is about the interference alleged by Ms. Ramos with the contracts that Ms. Cutler's company had with all of those people. Correct?
Yes, Your Honor.
All right. And there's not really any dispute, or at least I understand that after Ms. Cutler notified Ms. Ramos that she was no longer going to be an independent contractor, Ms. Ramos did reach out to several of those people and sent them some communications. Do you have a complete set of the communications or a complete message that Ms. Ramos allegedly sent? Because I saw kind of versions of it in those screenshots, but I don't know if there's like a more complete one.
That's what we have, Your Honor.
Okay, which exhibit is that? Or I'm sorry, Mr. Levy, is that all y'all have are those screenshots?
Yes, Your Honor.
All right, let's go back. Which one was that? That was the school platform record? Or no, the thread with Cutler and Magelson?
Yes. Which is,
Exhibit 7.
yeah, Exhibit 7, Your Honor.
Okay. All right, I'm going to share my screen and let's just all, well, I'm going to read it out loud and y'all can look along with me. Okay, and these are messages taken from the school app, right? Isn't that what we established earlier?
Yes, Your Honor.
Oh. Okay, and then there are 7 pages. Do any of them have timing on them, dating on them? This one says October 18th, so there's a date. None of the others do, so on or around then. All right, let's see. I wanted to reach out and let you know Camilla's no longer. So this is the defendant or the counter plaintiff responding to one of the clients saying, hi, I wanted to reach out, let you know that Camilla is no longer here. You can handle it through me and our team inside. If you have questions, make sure you're supported. You can book here. Okay. Looking forward to it. And then she goes, I did receive a long text email or a long text from Camilla earlier today. All right. All right. Is that a terminal arc, a sacral generator? I don't know what that is. All right, so this is at the bottom here. This is the text message that she says Ms. Ramos sent.
Yes, Your Honor.
All right, so this might sound a little intense at the start and it's long, but please read through it if you can, because I want to be transparent in the honor the trust you placed in me. I was let go by Allie. Greater sales supposed to be used as training material. You share personal things with me. So this is just a continuation. It's just sort of cut off. That said, I still believe in her program, one that made it flow and feel natural. I was so excited about it and offered to share the system with her. She declined, referencing profit margins and suggesting I should prove my. And then it drops off. So there's something that's missing there, right? Many of you
No, I
trust.
think yeah, it continues there.
Yeah, that's. Then again, there's no agreement between the parties that she can't poach. There's literally nothing that prevents Ms. Ramos from doing this, right? Typically, I see that in these kind of independent contractor agreements that you promise, like in a hair salon, I get a lot of those. But to my knowledge here, the parties just like kind of had a very, very vague understanding and they only talked about commission rate. So while in other situations, this kind of action might be bad, it's not strictly prohibited at all. It's just, it's not good, but she absolutely says, hey, come to me and I'll do it for free. All right. And that's the final page.
Your Honor. Your Honor.
Well, Ms. Ramos, it's Mr. Levy's turn at the moment.
I'm so
All right.
sorry.
So I can see that she sent a message to the clients. And there's absolutely no doubt that it took Ms. Cutler time to respond to those things, but
It's the fact that she's asking for a commission when she was responsible for losing that commission seems to be that's what our issue is.
but Ms. Cutler only has to pay her for things she got paid on. So she's not losing those commissions. She's not suing. I would not award Ms. Ramos money on a commission that Ms. Cutler did not receive payment for. That was one of my very first questions to her. What happens if she never got paid? So it may be true that Ms. Ramos, by doing this action, caused people to cancel their contract, but the punishment to Ms. Ramos is she just doesn't get any commission on that. Instead, she did twice the work for nothing.
Sure, but there is a substantial loss to Alley Tate US LLC because of that.
Has she a substantial loss? Because what I saw from the spreadsheet is that she pretty much convinced everyone to stay. And in fact, some of them she sold a better package.
There was at least
She
two
collected
people
enough money that she owes $5,000 in commissions to Ms. Ramos.
on Exhibit 7. There's two people that Exhibit 8. No, Exhibit
Take a look at 8. I just read through 7.
4. I'm sorry. The first page of Exhibit 4 shows the two people, Rachel Cole and Linnea Shanley, who completely took money back out of the program and got full refunds after receiving that message.
So she refunded them their money. Did she reduce the commission owed to Ms. Ramos in her spreadsheet?
Yeah, I believe
Right?
that's
Because
the
like,
case.
if Ms. Cutler was paid, let's say she got paid $1,000, and she's like, all right, I'm going to give $170 to Ms. Ramos for a commission. And then the next month that client calls and says, I'm canceling because Ms. Ramos badmouthed you. And Ms. Cutler sent back the $1,000. I would agree that Ms. Ramos needs to give her back $170 because it's her fault that the client refunded. And she doesn't own a commission because essentially Ms. Ramos and Ms. Cutler never got paid. So for
Correct.
these two, Ms. Cutler refunded $1,000 to each of them. Rachel Cole wants $1,000 back. Lindsay,
I'll let Ms. Cutler explain because I don't know the facts. I don't want to testify. I only agree to testify on as attorney's fees.
I understand that, Mr. Livy. I appreciate that.
I definitely do not want to be misleading the
I
court.
appreciate that. But Ms. Cutler, I can see there are two requests to withdraw and a refund. One of them is from a woman named Rachel Cole.
Mhm.
She's the one who says, I didn't know y'all were going to take 613. I wasn't prepared for that. I want my $1,000 back. And the 613. So she wanted back 1613. And then the other one was from a Linnea Shanley.
Rachel
And-
Cole had put $1,000 deposit down and then the 633.33. She was upset about the second charge, possibly because it hadn't been communicated correctly.
Yeah, and I can understand that, and that happens. And I'm not saying that y'all didn't communicate correctly. These things happen all the time. What I'm asking is that did you refund the entire 1613 back to Ms. Cole?
Correct.
Okay. And how about for the other one here, Miss Shanley? Did she receive any type of refund?
Linnea Shanley was credited, not refunded. So we credited that 1633 to her account. We're like, hey, when you want to come back in, this is good for a year. You will be able to pay the duration. As I said, Camille said, I do have contracts for them, so she can finish the duration of the payment and use that credit for it.
All right.
I think the point we're making is there's a 4,500 minus 1633 is 2,867 that the company lost as a result of those people dropping out of the program.
Well, only one of them she gave the money back. The other one she got to stick around.
The date of her credit is now expired, so she's not coming back.
Yeah, but y'all got her money.
Less than a quarter of the money.
All right. But Cole, you refunded back all $1,600.
All $1,600, correct?
All right, so of that, 272 would have been the commission that got paid out to Miss Ramos from it. That's 72, that's 17%.
Yes.
All right. All right.
Oh, and sorry, just to make sure, I want to amend what I said earlier because I was frantically looking up to make sure I'm not committing perjury.
Okay, Ms. Keller, I appreciate that.
Okay, so I looked up past January to make sure. It gets a little muddled because there are people who continue on with us after the date that Camilla signed them. So with what Camilla signed them, this is what I can see. And I hope I'm right and that I'm not actually giving her credit for something we upsold them to, but this is what my record said. For Palmas, Michaela, the names she mentioned, Emily, Baldwin, Michelle, Katie, and Michelle N. With all of the money that came in it was up, some of them came in January, she's owed an additional $1,690.81. And that I can verify, hand to God, I have done my research. There's nothing left on the table here.
All right, so that's also owed to her?
Yes.
All right. So that brings me to 67.87, 1 penny. All right. Now, I'm so sorry. I'm going to say you, Miss Camilla, Miss Cutler, Miss Cutler.
Yes.
Now I definitely see that you spent some time having to go back and an effort with the parties after Ms. Ramos sent that email. And I've seen the emails where you offered a refund, you offered a credit. Were there any other things that you have that would show me sort of the efforts or the actions you had to take as a result of those emails that went out or that text message?
Yeah, so there was however, she signed 15 or 16 clients. So I had to send 16 different emails, track them down either via school, email, or text message. And if they didn't respond, I had to call them. And then when I got in communication with them, I offered them all a 1 hour free coaching call because I was like, look, this is really messy. I'm really sorry about that. I know we look unprofessional. Let me make this right. And I'm going to take a 1 hour coaching call with you. And for 9 of those women, I took a 1 hour coaching call. Now I know that in the eyes of the court, like people pay me $997 for a 90-minute business consultation. And in the eyes of the court, that is like far too high and I'm not asking for that. But I did do 9 hours of one-on-one calls with people who would not have had that option.
All right. Anything else?
For me?
Or related to the counterclaim, any other evidence you want to show me? So I see the information related to her contacting the parties after the fact and then certainly, offering to have them come to be with her.
Yeah, I think that it would be probably important to say that like the most important thing to me at the beginning of this was the withholding of my sales call. And as you say, we didn't have a contract, but the messages, WhatsApp, written and otherwise, that we have between each other, she was aware that she was doing work with my business, my leads, my CRM, my system, my pitch, my sales call. All of it is our material. And so the whole contested idea that she owns those sales calls is not true because she wouldn't have had those sales calls if it wasn't for my business.
I'd say that is where a contract just explains that clearly to everyone. A reasonable person could argue both sides of that, and that's why, as the judge, I'm glad I'm not having to decide that.
Sure.
But I think there are many ways that those can be written. So if it's really up to what's reasonable to both parties, reasonable can be pretty broad. But okay.
Oh, and can I add one more?
Shared by both parties, Your Honor.
I'm sorry, Mr. Levy?
They can be shared by both parties. They're digital, they're data, so both parties can have access to them.
Oh, yeah, no, I thought you said they can't be shared, and that's why I was a bit confused. I was like,
My apologies.
No,
They can
it's
be shared.
hard to hear some of that. All right. Yeah, no, all right. Anything else on the counterclaim?
Just the attorney's fees.
Okay.
And to date, we have $18,670 in attorney's fees, and that was before today, not including the trial.
Is that just for this matter?
Yes, Your Honor.
All right, would you like to make closing statements now? Ms. Ramos, you're both the plaintiff and the counter plaintiff. So as kind of the way we would do this is you would get to give me a kind of a summary, like a wrap-up summary for your side. Mr. Levy gets to do the same thing. And then technically, Mr. Levy, you both get a chance to kind of have a final bite at the apple because you're both a plaintiff of some sort. But let you both give me a final statement and then I'll make some outcomes. Okay, go ahead, Ms. Ramos.
Your Honor, prior to a final statement, I have some points that I'd like to contest regarding what was brought up that I've been waiting for.
Go for it.
So, first of all, regarding the recordings, I was happy to share access to them during the term that I was with Ms. Tate for review. But when Ms. Cutler, requested them for training purposes, that is where I drew the line. Because the calls took place between, I didn't think it was appropriate, and legally, I was in Florida where the calls took place. Florida is a two-party consent state, and without consent, they cannot be used for-profit per Texas law. So it gets kind of confusing with that, but the calls were requested for training and ownership of the calls was requested, which is where I objected. Ms. Tate was creating a video training program for closers, and I also, the script that I used on the call was proprietary. So even if they are commingled assets, they wouldn't be able to be used for the for-profit training activities. And that's why I refused. I also want to point out that in Exhibit 7 of the defendants with Ms. Katie Magelson, it shows that Ms. Cutler offered free calls to her clients prior to knowing about any text. This was an action that Ms. Cutler offered independently of anything because of the termination of someone that was a coach and a closer. Sorry. And also regarding the refunds that were issued, there's no evidence that the cancellations were directly due to me. On the contrary, what it shows is that Ms. Cutler agreed to refund. She went against her own contract. She made that choice and she actively had to sign on and give those refunds. And I also have, I also want to point out that for the claim of tortious interference, there has to be. Oh, okay. Okay. Well, if that claim is not there, then that's okay. And then I would like the opportunity to review when I listed the clients that I had records of the payments going through. I appreciate Ms. Tate going back to her records. I would appreciate the opportunity to review all clients because I was only able to list a few examples and then I had to stop speaking. So in order to reconcile in this trial without having to then appeal, I would appreciate the opportunity to reconcile all of the.
You should have requested discovery before the hearing. We're in trial now. I have to make a decision. I can't wait for y'all to go and look for your financial records. That's something you could have requested discovery, and I would have had her turn over her financial records and vice versa, and then we could have sat and compared those.
Okay, then what I ask is that Ms. Tate, I guess, swear under oath that there aren't any other payments or that she doesn't want me to let her know what they could be so that she can make that true statement.
All right. Mr. Ramos, how would you respond to the allegations about you emailing 15 to 16 of the defendant's clients and bad-mouthing her and offering to do service for them?
I disagree that it was bad-mouthing. I have the full record of what I sent and specifically
Did you compliment her?
Yes, I did. Actually.
Tell them that you were concerned about her business practice and offer to do services for them instead?
I brought up gaps that I had also brought up to Ms. Tate that she agreed were gaps, that I have a video recording of her agreeing were gaps, and that I had solutions for. I want to be really clear. These clients paid thousands of dollars. Many of them had pressing financial circumstances that I was privy to. I felt that I was doing a good ethical thing by offering them something that could help them succeed in her program. if you review the message, it goes at the end, it really clarifies that. I also say, I'm not trying to pitch, I'm not trying to sell you anything. Like I have 3 other businesses, Your Honor. They have nothing to do with this. I have no reason to compete with Ms. Tate, even though I would have had the right to. And then in further conversations, and especially with Ms. Cole, I share with her like, hey, this was a huge investment for you. I would love to help you take advantage of it. I wanted them to succeed in Ms. Tate's program. I want Ms. Tate to succeed. I want everyone to succeed. And I made that clear in all of my text messages. I thought it was a very objective and positive message. But I understand that there were things that there were gaps. I didn't say anything defamatory. I didn't say anything that wasn't true. Anything that I didn't already have brought up to Ms. Tate. You can see that in my exhibit F1, I message Rachel Cole. It goes through our entire conversation. Also, just where I let her know what her payment plan was and that she would be receiving a contract from Ms. Tate. I also have, of course, a text message where I let Ms. Tate know to send the contract. Mr. Levy's and most recent response filed said that they had an active contract with Ms. Cole.
I'm looking at your exhibit, Ms. Ramos. You said to
F1, thank you.
look at F1. So this is an
Yes.
email chain that starts,
It's
actually, it's like a text
page
message chain.
Text
13,
message.
I think, is when she sent the message.
I'm sorry, Mr. Levy?
Page 13, I think, is the message that you were asking for a full copy of.
Oh, okay. Are you looking at this as 17 pages? Do you have that?
Yeah, I'm looking at F1.
Okay.
And I'm saying on page 13 of 17 is the message she sent.
Okay. I'm getting my bearing on what I'm looking at here. So I can see at the top of page 1 that we're in September of 2025. And the first one in blue, it appears to be the plaintiff Camilla contacting one of the third parties, one of the clients that she'd signed up. All right. And
It goes through our entire.
I got it.
Sorry, I'm sorry.
17 pages. I gotta read it and see what it
Okay.
is you sent me, right?
Thank you, Your Honor. Thank you.
So I see that she's responding. Hey, Camilla, thank you so much. She talks about money issues. All right, I see in September, you're giving her 7 steps to go ahead and pay. I'm on page 8. I'm still reading this chain of lines, right? Lots and lots and lots. Oh. Okay, so she attends a class, she learns a lot. Didn't make this class. Good morning. Okay, so I see the change. So all the messages are good, and September 15th, final message from the plaintiff. It's awesome. Sounds like you're ready for today's call at 1 p.m. Okay. And then we jump forward in time quite a bit because the next message is October 17th. So we are now a month and 2 days later. And this is the long message from Ms. Ramos.
Correct.